I applied for the PA, physical hand.
But your name featured in the
General
list of
category.
general category.
General category. मतलब least will मतलब now I came to know.
What is the urgency?
मतलब urgency मतलब the interview will call next week. मतलब from my
When the interview will start?
मतलब date दिए थे interview? 29th मतलब.
Yes, Miss Banerjee, when interview will start?
It is for 11 and
9, 9, 10.
9, 10 जाने ना.
कौन subject?
instruction on that. To know with this 11 and 12, it's already started. And it will
So for 9, 10 are concerned.
kindly allow me to take the instruction.
Yes, when interview will start?
मतलब as per my knowledge, my client that next will they tentative.
You obtain the date and then mention tomorrow. I will allow. When interview will start? Do you know? 11, 12, 9, 10.
From January
friend told me that the division bench also yesterday allowed such.
Your Lordship, interview will commence from January 2026.
I have to mention, my lord.
If interview date is fixed, then mention.
Interview date will be from January 2026.
Quotum number 18. Quotum number 18, my lord. The urgency is that, my lord, the petitioner, my lord, participated for the post of assistant teacher for the subject of agriculture. Only one seat is reserved for the SC category, my lord. After, my lord, the completion of the written examination, the result was published, my lord. I am qualified. Thereafter, my lord, 2 names were selected for the document verification and the interview. At the time of document verification, my lord, the cutoff mark was 51. On whose marks, my lord, selected as a cutoff mark, each candidate was cancelled. Only one candidate is remaining, my lord.
What is the urgency? You did not achieve cutoff mark?
The only one.
Sorry. Yes.
My lord, may I have your lordship's kind leave to mention 2 matters that was taken up yesterday, my lord. But because of a bereavement in my family, my lord, I had to the crematorium, my lord, and could not come, my lord. Your lordship has been pleased to fix the matter, my lord, on 14th of January. My lord, the difficulty, my lordship, to tell it, my lord, there is an order which protects me, my lord.
Sorry, matter was called
Not,
on. Sorry.
May I have your
Yesterday
lordship's
matter
kind,
was called on. I have fixed the matter. Come on 14th. Sorry. Yes.
may I have your lordship's kind leave to
Yes,
mention this matter, this regarding the urgent determination of Honorable Justice Amrita Sinha, my lord. The petitioners are teachers teaching in schools affiliated to the West Bengal State Council of Technical and Vocational Education, my lord. The prior teaching experience of 10 marks, which is
Vocational education does not come under the determination of
but
Justice Sinha.
these are schools.
Vocational education does not come under the determination of Justice Sinha. It comes under the other educational matters.
But this is the I'm not telling that this is not a matter in regard to the vocational training. I have been debarred the 10 marks prior experience in respect of the second SLSC for the 11-12 teachers, and they say that since
that issue, they said, is not a regular bench. That issue cannot be decided. It requires hearing.
the interview is at
Maybe,
is
but I
is
cannot,
on
at that
29th.
stage, court cannot decide the issue.
29th, I'll be debarred from the
Yes.
interview.
Yes.
I'll be
Because
debarred from the
it
interview
requires
because
hearing. Sorry. Yes.
but will kindly
lordship, may I be
appreciate that this will become
No,
infructuous,
no,
madam.
regular bench. Yes.
Your lordship, may I be permitted to mention one matter for inclusion in the daily list? I'm a serviceman of the CRPF.
Yes.
By the order of 5th December 2022, I was awarded compulsory retirement. I have appealed before the concerned authorities. I have made my first appeal on 28th December 2022, which was dismissed. And later on 11th 4 2023, I have made my second appeal, which is pending. Now,
Why you are mentioning today? Today is not the date for mentioning. These matters are being mentioned, which are extremely urgent. You are mentioning with regard to a disciplinary proceeding matters where you went right up to appeal stage. Mention on Monday.
lordship, kindly once reduce your lordship's order, my lord. One.
What can be done? Matters were called on. Prayer was made for adjournment. I have fixed the matter on 14th. Sorry. Yes, please call the list. No, sorry.
Protected the petitioner.
Sorry, matters were called on. Sorry.
I had a bereavement.
Others are regularly mentioning the matter. I cannot take those matters from the combined list. Sorry.
Item number 1.
Come up on 14th. I will consider. Yes.
There was a protection that
Yes. What is the matter?
But that is why I was mentioning, my lord. Otherwise, I would not trouble, my lord.
The petitioner is a physically handicapped candidate. You also will find page 45. As per first SLST, he was recommended under the physical handicap category, and he was appointed. And being untainted 20 candidates, my lord, he is continuing in service till 30%. Also, we will find also recommendation, appointment, and approval under the PH category. But as per the notification, second SLST.
Recommended untainted candidate. Yes, now what is the urgency?
Page 71, he applied, my lord, for assistant teacher in 11 and 12, second SLST, page 71. My lord, he applied under the physically handicapped category, paid the fees of rupees 200, prescribed, my lord, for reserve category. You will also pay 71.
Yes.
Middle portion application fees.
SCSTPH, yes.
200 rupees, my lord, that is the as per rules.
So you comes under which category? You come under which category?
Physically handicapped category. Now thereafter, my lord, he appeared at the written test examination also, my lord, under the physically handicapped category, and you will also will find result was published page 76.
Yes.
76, my lord, he got, my lord, 70, that is out of 80, cut-off marks 55. You will also got it, my lord.
Yes.
And cut-off marks. Vacancy category, PHOH, physically, orthopedically.
Yes.
Physically handicapped. My lord, after the result was published, that is, verification was started, page 77. That is also, my lord, the valid PH certificate from the competent authority. At the time of verifications, my lord, everything has been verified.
At the time of verification?
My lord, the physically handicapped certificate has been verified. You will also pay 77. My lord, after the verifications, my lord,
where is the verification?
Yes, this is the verifications. My lord,
PH certificate from competent
documents, my lord, testimonial certificate for verifications.
Yes.
Yes, that has been verified. After that, my lord, the preliminary list has been published for interview, page 79.
Page
79. Serial number 1. The petitioner, my lord, the PHOH, male, 70.
What is this list?
This is the preliminary list for interview. My lord, after the verification, list has been published.
Yes.
Thereafter, my lord, page 79A, my lord, the commission published a list of disqualified candidates. Now the petitioner's name is appearing, my lord,
Three.
My lord, not in cutoff due to category change. Previous category PHOH, current category Jane. Total marks 70, cut-off marks 71.
Yes. So that's why you have been kept out of the
category
contention.
55, my lord,
Yes. Why there is a change of category?
Yes. Malad, first of all,
Who is
Malad,
appearing for the commission?
My lord, I am appearing for
Yes.
the commission.
Why there is change of category?
As per instruction, my lord, we do not have vacancy in that category. The PHOH, my lord, that is OH is others. It is not
orthopedic.
Orthopedically handicapped.
no, my lord. It is others. It is not orthopedically handicapped. That we are categorizing under the state is categorizing under the locomotor disability.
Yes.
So, my lord, we do not, the state has not given us any vacancies in that category so that we can adjust the writ petition.
So there is no vacancy under the differently abled candidates.
No, it is there.
There is no vacancy earmarked for differently able candidates or PH candidates.
Page 80.
But
page 80. I have annexed, my lord, the vacancy list. Mathematics,
Yes, mathematics PG.
Above mathematics, the unreserved 8, serial number 8.
Serial number
Six.
9, if Mallet kindly comes to serial number 9.
PHOH.
8.
8.
6 vacancy.
Yes.
Mallet
O
OH
is-
is others, Mallet. It
Yes.
is not
Orthopedics.
construed as orthopedically handicapped. Mallet, if kindly.
Is there any classification of vacancies under under the differently able category?
Yes.
There is, Mallet.
Where is such demarcation based on classification or sub-classification under PH category?
There is only in 9 we have, but that is SC.
Where is such sub-categorization or sub-classification under each category? Show me that sub-categorization. That this is, say, for example, there are 20 vacancies earmarked under PH category. Out of 20, these are the sub-classifications.
Kindly takes up this Gazette notification of 2019, Mallet. The 2D, 72nd vacancy.
No, there must be a pool of vacancy under PH category. Now, under pool of vacancies, where are the subcategorization? Court is not disputing your submission that yes, that there cannot be any subcategorization. There can be subcategorization for orthopedically handicapped, locomotor disability of lower limb, locomotor disability of upper limb, visual impairment. There might be certain classifications, but where is such subcategorization?
हमसे पूछ नहीं रहे
In order to demonstrate before this court that there is no vacancy under PHOH category, as a result whereof petitioner was thrown out of contention and is treated under general category candidate.
May I take 2 minutes to explain the situation?
Yes.
If it is, section 34 requires us to have 4% reservation under the 2016 Act, which was 3% in the 1995 Act. Section 34 categorizes these 4% where it is to be allocated. In exercise of that power under section 34 subsection 1, this notification which has been handed over by the commission has been made. Now, my lord, your lordship will find in that the 12th point is for the persons with blindness and low vision. My lord, I'll request your lordship, my lord, to read this notification, gazette notification, along with page 80. My lord, it will be easier for me to explain. My lord, kindly takes page 80 side by side. My lord, kindly take serial number 6 at page 80. My lord, serial number 6 is PHVH, that is visually handicapped. My lord, your lordship will find the corresponding entry at 12 vacancy.
What is VH?
Visually handicapped. That is
physically handicapped or
PHVH, physically handicapped, visually handicapped. That the corresponding, the roster point is the 12th vacancy in the gazette notification which I have handed over.
Unreserved persons with disabilities,
blindness and low vision. Now, my lord kindly takes serial number 7 at page 80, that is PHHI, that is hearing impaired. Hearing impaired, your lordship will find at the roster point number 42. Deaf and hard of hearing. This is hearing impaired. Then your lordship will find serial number 8 at page 80, PHOH. This OH is being entire foundation of the writ petition is that O means orthopedic. But OH is other disability. Your lordship will find at vacancy point number 72. That is persons with disabilities, autism, intellectual disability, specific learning disability, maintenance, and multiple disabilities. These are OH. Then, my lord, serial number 9.
Disabilities.
Other disabilities. Because, my lord, all this cannot be made a short form, so other disabilities. This is what was added in the 2016 Act.
72nd vacancy is required to be reserved for PHOH. Then why? Because there are vacancies under 100-point roster, much more than 72 vacancies.
Yes.
So why there is no categorization under PHOH identifying 72nd vacancy?
72nd vacancy is PHOH.
PH. So in this case, you are submitting. He is submitting that there is no vacancy under
no.
PHOH.
Under, I'll come back. If I may answer only after showing
I
serial number
accept
9.
your contention.
But kindly take serial number 9 that answers the question. Serial number 9 kindly takes PHLD. PHLD is the roster point number 32. That is locomotor disability. Kindly takes in the notification 32nd vacancy point.
Locomotor disability.
Now, my lord, why my learned friend is saying that there is no vacancy as the petitioner wants, because kindly sees the 32nd vacancy is scheduled caste. It is not unreserved, unlike 12, 42 and 72. Therefore, when the petitioner is applying under OH, petitioner is not belonging to OH category. Petitioner is belonging to LD category.
According to you, petitioner applied as PHOH.
But he was LD.
It is persons with disabilities, autism, intellectual disabilities. These are the disabilities.
Yes.
It is 72nd vacancy.
But he is not under that. He is not under the category of autism, intellectual disability, specific learning disability, mental illness, and multiple disability. He is coming under locomotor disability. Therefore, he will fall under.
So petitioner is not a candidate under PHOH.
No. That is why at the time of verification.
What is the categorization of the subcategorization under so far petitioner is concerned?
LD. But that is reserved for SC, which your lordship will find at page 80, serial number 9.
PHLD is 42nd vacancy.
Yes.
42nd
No,
vacancy.
32nd.
Locomotor disability.
Yes.
So that is scheduled caste candidate. That is for scheduled caste candidate.
Yes. Malad,
Petitioner is
we'll
not-
kindly keep scheduled caste at the side for the time being. Keep it
So
aside.
petitioner is not a scheduled caste candidate.
First question is whether the petitioner is OH or not. Malad, by the O, every petitioner will, every person, applicant, Malad, I'm sorry for using the word petitioner, every candidate will interpret O as their, someone will say it is ocular handicapped. Someone might say it is orthopedically handicapped. But that is, question is whether the petitioner is OH or not. Whether it is SC or not, that is the secondary question.
Where is the disability certificate?
Petitioner disability certificate.
Where is the
Petitioner
disability certificate?
43.
You are treating the petitioner as PHLD, locomotor disability. Yes, lower limb.
Malad, paragraph
Disabled and has got mild, weak, then mild, weak of right lower limb.
right limb.
But what is there after weak? I can't read.
Malad, it will be Malad.
Mild, weak.
Your lordship may take the pleading and paragraph 3. Malad, that will clear any doubt.
It is PHLD, locomotor disability. Weak, right limb, lower limb. RL, lower limb. So it is locomotor disability.
43 first paragraph, considered as orthopedically disability.
Right. So he is not autism.
That's true.
So it's not coming under other disabilities.
That melody that I was first SLST, I was recommended at PHOH.
Forget about first SLST.
As per the decision of the Supreme Court, that vacancy has been advertised. I tell you,
Court has to consider the present position.
present position.
On the anvil of 2016 Act, Disabilities Act of 2016. Now in 2016 Act, if there is subcategorization and there is a notification issued by the state government, then in that event, yes, you are a disabled candidate, you are differently abled candidate, but your categorization comes, your category comes under PHLD. If it is PHLD, then then the vacancy should be 32nd vacancy, which is reserved for scheduled caste candidate. Applying 100-point roster.
The page 71, I applied online category PHOH. I don't know, my lord, this is the 2019 notification. Prior to the judgment of the, prior to the notification,
So what?
2016 rules, 2025 rules. 2025 rules, my lord, the category has been defined. Your lordship, my lord, the kindly 71, your lordship online application.
My lord, when the persons were applying, I'm sorry to interrupt my learned friend.
Regarding
My lord, there was no
categorization of
doubt.
vacancy,
Kindly cease.
identification of vacancy, in Sanjay Dolui, I delivered a judgment which was upheld right up to Supreme Court. It was not interfered with.
But in the
So therefore,
case,
court will not embark upon this categorization again. Now, if this is a notification of 8 July 2019, if you do not come under the category of PHOH, then the vacancy that is PHOL, if you come under that category, then it will be a 32nd vacancy. 32nd vacancy is reserved under 100-point roster is reserved for scheduled caste candidate. You are a general category candidate.
My lord, at the time of selecting the option, I have handed over what
This is your disability certificate. It is not keep a copy of this notification if you have. Yes, come to the categorization. It is 2019 notification, much before initiation of selection process of 2025, and 72nd vacancy unreserved persons with disability, autism, intellectual disability, special learning disability, mental illness, and multiple disabilities. You are not coming under this.
but the
Considering your disability certificate.
but the online application, verification, merit
There
list,
is a statement made in the writ petition regarding the nature of
Para
disability,
3.
which petitioner is suffering.
Para 3. Second line.
Being orthopedically disabled.
that's true, orthopedically disability, but the notifications reflects, my lord, after the 2025 rules, my lord, the commission, my lord, submitted, my lord, appointment, issued appointment notification, prescribed my lord, inviting applications from the candidate from all
How many
categories.
vacancies are there?
6.
Under PH
LD.
6. 6 vacancies. So if there are 6 vacancies, then first vacancy will be 32nd vacancy.
No. No, my lord, under PH, there are 25 in mathematics PG. Out of that 25, 7 are under roster point 12. 6 each under 32, 42, and 72.
7 under roster point.
12. Then 32, 42, and 72, there are 6 each. Because my lord, when the roster point is calculated, it completes a full circle up to 100, then goes back to 1.
Yes.
Then again, it comes to 100, then goes back to 1. It like that.
Rotation.
Rotation. Yes. By rotation, my lord, it has stopped somewhere between 12 and 32. So 12 has got 7, 32 has got 6, 42 has got 6, 72 has got 6. In the next round, whenever it's the next SLST, it will start from the point where it has stopped now. It will start from there. If it has stopped at 15 or 16, it will start from 16 or 17 in the next round.
So by applying rotation and applying 100-point roster, so there are total 12 vacancies.
25 under PH.
Under PH. Now for PHLD, how many vacancies are there?
6.
So within first 100, there will be 32nd. 32nd. In the second 100, again 1. So by doing, there are 6 vacancies under PHOH, LD. So if it is if 6 round is completed, in that event, this 32nd vacancy in the 6th round will be reserved for PHLD.
Yes.
Now suppose if in the 5th round it comes to an end, process comes to an end, then how the 6th vacancy will be accommodated under PHLD?
How
if if it is counted up to 532,
Yes.
then 6 vacancies can be accommodated.
It will end at 32.
If this, while rounding up or while rotating, applying 100-point roster, if the process ends at 510, says 510,
Yes.
then how 6 vacancy under PHLD will be accommodated?
It will not be. It will not be. And it will not be required also. I'll tell you, Lordship, why. Because by the time we reach 510, we will have, for each 100, we will have 4 PH. 4 PH in the first
Up to
100.
500, 3 PH.
So
3
we'll get
PH.
20 PH. So 4% is the requirement under the Act. For 510, 4% is 20 point something. So we'll have 20. So the mandate of section 34 will be satisfied. In the next round, whenever is the next round, maybe say SLST 2030, the roster point will be start counting from the 11th point.
So considering the number of vacancies, 100-point roster applies. Where it ends. While
now, Malad, I'll give
at the end point, say if it is up to 510, in that event, there will be 4 vacancies in first 100. Then another 4 vacancies in second 100. By doing this up to 500, there will be 5 into 4.
Yes.
20 vacancies will be
there. Which is 4% of 510. Now, Malad, kindly takes a different example.
4 multiplied by 5.
Yes. Malad, kindly
It comes to 20 vacancies.
Kindly takes a different example. Only 25 vacancies have been advertised. Only 25. In that case, you start at 1, end at 25. So there will be only one, that is
12 vacancies.
only 12 vacancies.
12 vacancies.
If it starts from 1, if it starts from some other number, some other vacancy will be there. Now 4% of 25 is again 1.
Yes.
Well, the page 79, I'll tell you, page 79, this has been published preliminary list for interview. Page 79A, well, my last
No, one thing is also troubling this courts of, it is a case of PHLD, locomotor disability. If it is locomotor disability, then it is 32nd vacancy. So all locomotor disability vacancies will be reserved for civil caste candidate.
Yes. Because Malad, scheduled caste, scheduled tribe and OBC, Malad, these are flowing out of 16.4, Article 16.4. These are all vertical. Other horizontal vacancies, Malad, flow out of Article 14, Article 15. Those are not class-based reservation. Those are horizontal reservations, Malad. The vertical reservations, when it is interlocking with horizontal reservation, Malad, the word used by the Honorable Supreme Court is inviolable. Malad, the vertical reservation flowing out of 16.4 cannot be violated. It is free from violation.
But if it is so, then if there are 500 vacancies, all the 32nd vacancies will be reserved for civil caste candidates.
Yes.
So a candidate
Who is unreserved.
General category PHOL candidate, or
LD
candidate, PHLD candidate will never be considered as
Malad,
as a reserved category candidate.
I'll tell you, Malad, there are two answers to it. Malad, first of all, if there is no SC candidate, Malad, first of all, it can be de-reserved. Number 1. Number 2, Malad, again going back to that argument, vertical reservation flowing out of Article 16.4 is not interchangeable. But horizontal reservation flowing out of Article 14 and Article 15 are interchangeable. Though, Malad, if required to accommodate, Malad, it is interchangeably, it can be accommodated.
But there is a fallacy in it.
But Malad, Malad,
if a candidate comes under the category of PHLD and he's a general category candidate, he will never be considered as PH.
In the first round, no.
Yes.
In the first round, before de-reservation or interchanging, he will not be considered. But I will, Malad, request your Lordship, Malad, not to go into that question in this writ petition. Because Malad,
this is not under challenge.
Yes, because the basis is not under challenge. The foundation of this petition is that O means orthopedic. Well, I can satisfy your Lordship, Malad, on that point, Malad. We had a rough idea that these questions will come. We have also come prepared with on that point. But Malad, the prayers will not justify going to that point.
It doesn't make sense. Always 30
it will, Malad. If I address your Lordship, Malad,
reserved for physically handicapped. So then what would be the fate of a physically handicapped locomotive LD candidate
General.
who is general.
But it will make sense, my lord.
Interesting
No, no,
point.
but it will make sense, my lord, if I address your lordship, my lord, on this aspect, my lord, because this has been dealt with. This has been dealt with by our courts, my lord, starting from Indraswamy onwards, my lord. Even recent judgments are there. There is RBI versus AK Nair. There is one of the most recent judgments, my lord.
Judgment.
Yes, 4th July 2023, my lord. Now, my lord, I can satisfy your lordship on that point, and I'm prepared, my lord, on that point. But question is that whether the prayers justify going into that point in this matter or not.
Because very basis of the writ petition is
Paragraph 3.
physically
That I am orthopedically disabled, that means I am OH.
differently abled, orthopedically disabled.
Which he could not ultimately justify that he is OH.
79A, my lord, that has not been, my lord, spelled out, my lord, by your lordship kindly see, that has not been stated.
That is a remarks column.
No, category has been changed.
Yes, I'll tell you why.
I'll tell you, lordship. Commission issued a notification for edit of the category. My lord, he did not, my lord, edit, my lord, his category, my lord, within time. My lord, now the honorable division man yesterday delivered a judgment that the yesterday 6 p.m. to today 6 p.m. all, my lord, the reserve category has been given opportunity to upload their, my lord, the category. I have also successfully, my lord, uploaded his category.
No, but here the case is
Here
this.
the case, my lord, that has not been.
That though you came,
Yes,
you
that has
participated,
been
you were
stated in
shortlisted,
78A.
but ultimately it appears that your category is under PH.
That is first time, my lord, they produced the notification.
No, no. I have handed over a document. Kindly see the categorization, single page. Malad, that single page, Malad. This I have handed.
It's not appear in 79A. Your lordship kindly see. They said what this category has been changed. Also rules, my lord, that has not been this, my lord, stated mentioned, my lord, in the rules. Notification.
In
that
the application, was there any indication that anybody can appear under PH, LD or PH?
It is there in the advertisement that how many posts are being advertised, Malad.
Yes, under physically handicapped PH category, whether there was an indication of subcategorization in the advertisement. Or a candidate having physical valid disability certificate can apply under PH category without mentioning subcategorization. Where is the application form?
A candidate also I did not apply
Malad,
because I am physically handicapped.
Page 76, kindly see. Page 76.
Because I did not
Just a
apply.
minute.
No. He is applying under OH. He is giving a disability certificate of LD. Therefore, my lord, when it is not at the verification,
Page 71, your application says application fees SC, ST,
PH. That is for the fees.
In broader respect, it
Kindly
was
676.
No, category, page 71 category, just 3 or 4 before that category PHOE.
that you have filled up.
I have filled
He
up.
has
So at the verification, he cannot.
Candidate under PHOE.
OH means other handicap.
Yes.
Handicap, my lord, I was appointee, I W just, my lord, under the
No, at the time of submitting this application, whether you had any opportunity to apply under PH OL.
হতে পারে না কারণ এখানে OH এর অপশন আছে
PH LD, not OL.
এখানে
PH LD.
OH এর অপশন আছে মানে LD এর অপশন থাকবে না কিন্তু এই কথাটা লেখা ছিল কিনা দেখতে
category PHOE. That is why, my lord, I have given.
Mr. Bandyopadhyay, if in the at the time of making application there was no option other than PHOH, how petitioner can apply?
It is impossible, my lord. What the petitioner is submitting, then everyone has to make an option of OH. There was an option of similar to what the petitioner has filled up. There was VH also, there was HI also, there was LD also.
These options were there.
Yes. Otherwise, how? I asked this question to myself: how he chose OH, and why he chose OH? He has chosen OH on the basis of his misconception that OH means orthopedically handicapped.
That could not have been published. Result was published page 76.
Correct, because
I got the
result is before verification. Result is before verification.
So according to the respondents, this at the time of submitting online application, this
Option was there and he has chosen OH. Yes.
And result was published page 79. I could have, my lord, commission could have, my lord, disclosed, my lord, the result at the time of publishing result that no, you are not PHO,
Printed.
page 76.
But
Thereafter list has been published. I can, my lord, apply, my lord, the change of category under the PH to OBCA.
Malad, it seems that he has edited also his option once.
after the notification.
Because Malad, the last date of
Terms.
application was 21st July. Right?
First July.
21st of July. Kindly see page 72 when
Added
this
terms.
page 71 has been printed. Page 72 kindly sees. 72 bottom kindly sees. 29th August he has printed it. This is the time when the edit option was there. So he has edited it to PHOH.
Where?
No,
But at the bottom of 72. Middle bottom.
Page 72.
72 in the fine print generated on Friday, August 29, 1915 hours.
Yes, 1915 hours.
So this is much after the last date of.
What is this document?
So this is his application
Academic
form.
qualification.
His application form, which he has edited also, out of his own volition.
I do not understand.
I am understanding that you could have generated this on August 29 after almost 1 month of the last date of application because you have availed the facility of editing the category. The commission allowed everyone to edit their option.
Why, my lord,
But merely because the petitioner has wrongly given his category, he has not obtained any right to challenge the process.
No, this, my lord, I could not, my lord, the change of edit, my lord, my change of category.
Then how could he print it on 29th of August?
That is the printed, my lord, after the 29th August
It's
20.
generated. It's not just printed. It's
Generated, yes. Generated on 29th of August.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop.
And just before that, my lord, I am a OBCA category. My lord, the OBCA candidate, my lord, I did not apply because I applied, my lord, under PhD.
Matter is heard in presence of the learned advocates representing the petitioner, state respondents, and West Bengal Central School Service Commission for short commission, quote unquote, close bracket. Next slide. Learned advocate representing the petitioner. Participated in second state level selection test 2025 for being appointed as an assistant teacher of mathematics for classes 11 and 12. Stop. Petitioner applied under. Now, petitioner applied by submitting online application declaring himself as differently able candidate under which is other handicap category. Other handicap other handicap within bracket PHOH close bracket category. Stop. Petitioner participated in the selection process. Petitioner participated in the written test and under PH category, and initially petitioner was treated as a PH category candidate who was awarded 70 marks, whereas under PH category cutoff marks was fixed 55. Stop. Reliance is also placed on a document at page 77 of the writ petition, wherefrom it appears that validity of disability certificate of the petitioner was accepted by the commission. Stop. Next paragraph. You know.
এটা না যেটা বলতো
Grievance of the petitioner is
Not that I know.
while preparing a list of candidates for participation in ensuing personality test, instead of PH wage category, he was considered under general category male. As a result whereof, petitioner was not found eligible to participate in personality test. Stop. It appears from page 79, capital A of the petition. Under general category, 71 was fixed as cut-off marks for participation in personality test, whereas petitioner obtained 70. Stop. Next paragraph, it is contended that petitioner ought not to have been treated as general category candidate while considering candidature of the petitioner for participation
unable to accept the argument of Mr. Kaur
personality.
after extending benefits of the regular teacher to the said 313 voluntary teachers now cannot turn back and say the approval of regularization.
Prayer is made. Now, next paragraph. Case is made out in the writ petition that petitioner is orthopedically handicapped, therefore he should have been considered as differently abled candidate, and considering marks awarded to him, that is i.e. 50, that is 70, he is required to be required to be given opportunity to participate in ensuing personality test, as under PH category cut-off marks fixed is 50. Next slide. Learned advocates, Mr. Bandopad, Mr. Shishanno Bandopad, learned senior standing counsel representing state respondents, submits that petitioner applied under physically handicapped as well as orthopedically handicapped candidate, which comes under subclassification PHLD having locomotor disability. In this regard, attention of this court has been drawn to the statements made in paragraph 3 of the writ petition, wherein it is averred that petitioner is orthopedically disabled. Stop. Another limb of submission made on behalf of state respondents is based on order dated 8 July 2019, issued by Chief Secretary to the Government of West Bengal under Section 34 within bracket 1 of Rights of Persons with Disabilities Act 1961.
2016.
Rights of Disabilities Act 2016, which prescribes 2016. Stop. As per order dated 8 July 2019, as per said order dated, stop. Copy of the said order is placed before this court and same is taken out. As per said order dated 8 July 2019, applying 100% roster at the time of identifying vacancies. 30-second vacancy needs to be earmarked for scheduled caste candidate who comes under persons with disabilities hyphen locomotor disability including cerebral palsy, leprosy cured, dwarfism, acid attack victims and muscular dystrophy. Stop. Under clause 2 of said government order dated 8 July 2019, 72nd vacancy is classified, or 72nd vacancy is earmarked for unreserved category candidate having other disabilities, that is autism, intellectual disability, specific learning disability, mental illness and multiple disabilities. Stop. It is submitted considering the case made out in the writ petition. Petitioner ought not to be treated as PHOH candidate. Rather, petitioner is required to be treated under PHLD candidate, as it is described under clause 2 within bracket small b of the said order dated 8 July 2019. Stop. As it is further contended as, next paragraph, it is further contended as 32nd vacancy is to be reserved for physically handicapped and physically handicapped candidate having locomotor disability. And in paragraph 3 of the writ petition, petitioner declared himself as a person being orthopedically disabled. He is not entitled to get the benefit of such reservation. Under 32nd vacancy as envisaged under order dated 8 July 2019, as the petitioner comes under general category. Stop. Therefore, according to the respondents or respondent authorities, according to respondent authorities, petitioner was treated as general category candidate but considering the marks awarded to the petitioner, that is 70, he did not come within the zone of consideration. Next paragraph. Next paragraph, learned advocate representing commission reiterates the submission made on behalf of the state respondents. Next paragraph. Having considered the respective submissions made on behalf of the parties and case made out in this writ petition, court is required to consider the prayer of the petitioner, or court is required to consider the prayer of the petitioner on the anvil of order dated 8 July 2019, issued by the Chief Secretary to the Government of West Bengal, Labor Department, Chief Secretary to the Government of West Bengal. Stop. Government of West Bengal within bracket Labor Department. Stop. It is specified under clause 2 of Government Order dated 8 July 2019 that 32nd vacancy is reserved for locomotory disabled candidate, or is reserved for disabled candidate having locomotor is reserved for a candidate having locomotor disability and applying 100-point roster if the said vacancy is 32nd. In that event, it is reserved for scheduled caste candidate. Had the petitioner been considered as disabled candidate having other disabilities as specified under clause 2 within bracket D, then candidature of the petitioner could have been considered against 72nd vacancy, which is reserved for general category candidate. Stop. However, there is no dispute relating to nature of disability of the petitioner based on averments made in paragraph 3 of the writ petition that petitioner is orthopedically handicapped. In addition thereto, disability certificate is attached at page 43 of the writ petition, wherefrom it appears that petitioner had a deformity in lower limb, which corroborates the statements made in paragraph 3 of the writ petition relating to nature of disability. Stop. Next paragraph. Therefore, court needs to proceed on the premise that petitioner can be accommodated against 32nd vacancy, applying 100-point roster, which is reserved for differently able candidate having locomotor disability, and said vacancy having locomotor disability. Stop. Admittedly, petitioner is general category candidate. Therefore, his candidature cannot be considered against 32nd vacancy. Stop. As a result, stop. Stop the kedel. As a result whereof, petitioner was treated as general category candidate to accommodate him in the ensuing personality test, but considering the marks awarded to the marks obtained by the petitioner, he did not come within the zone of consideration. as he did not come within the zone of consideration. Stop. Petitioner obtained 70, whereas under general category, cutoff marks was fixed 71. Next paragraph. Before parting with, it appears that clause 2 of the order dated 8 July 2019 prescribed reservation of reservation of a post against 32nd vacancy, which needs to be reserved for scheduled caste candidate having locomotor disability or other disabilities described in clause 2 within bracket B. Stop. If clause 2 within bracket B is applied, in that event a situation will crop up where only scheduled caste candidate having locomotor disability or other disabilities defined therein will get opportunity of reservation under PH category, denying the right of general category candidates or other category candidates having locomotor disabilities, having specified disabilities under clause 2B to be considered against said specified vacancy. Stop. However, such consideration in the present case is purely academic, as no case is made out in this writ petition. Rather, in paragraph 3, it is averred that petitioner is orthopedically handicapped. Next paragraph. In aforesaid conspectus, writ petition stands dismissed. However, there shall be no orders to post urgent. Point is kept to.
But serial number 4 takes care of it, but it requires a bit of hearing on that point.
Only one thing, Melody had stated, Melody, petitioner is a untended teachers, Melody of first SLS.
So if he is untended teacher, he has got a
he will continue till the Honorable Supreme Court has given the timelines, and thereafter his fate will be determined by this selection process. The Honorable Supreme Court has not directed all untended candidates to be continued for permanent.
Saying that I'm saying that the statement that he is an untended teachers under first SLS students. Because he was appointed under PH. He is a teachers মানে approved teacher.
ওর যেখানে সাবমিশনটা মিস্টার জানার রেকর্ড করা আছে ওখানে শেষে একটা দিয়ে দেবি ইট ইজ অলসো সাবমিটেড দ্যাট পিটিশনার is an untainted candidate who got appointment in connection with first state level selection test 2016 for classes 11 and 12. For classes 11 and 12, and he is working as an assistant teacher at present.
And under PH category, he was appointed. That has been mentioned in the recommendation approval.
Stop. Yes. Next one. Wait for me.
Two. Pursuant to lordship direction of submitting the deficit court fees, my lord.
It was filed on Yes.
And appearing for the state matter laid by learned advocate general.
But in this matter, the petitioners are concerned. They are all BSc pass male candidate. And my lord, they have been shut up.
BSc pass?
BSc pass.
BSc.
BSc.
Public Service Commission.
Yeah, no.
Yes.
BSc.
BSc.
BSc. Bachelor of Science. My lord. My lord, they are all male candidates, my lord, who has been shut out by subsequent to an amendment came into the effect of 2018. 2015, there is a provision, there is no indication of male and female, but 2018 is concerned, my lord, there is a clear indication that BSc female candidate has been given priority and rather
where priority is given?
In the government of West Bengal, those who are want to serve their service as a nurse, there I will not get any chance as a male candidates. But my lord, kindly
what is the challenge? Let me see.
that is the challenge, that amendment.
So there is no scope for passing any interim order at this stage because you have challenged
Because there is a subject to
challenge sub rule 2 of the West Bengal Nursing Personnel Recruitment Rules 2015.
Right. Prior to that, my lord, I have filed one public interest litigation. Wrongly, it was stated in service matter, it will not lie. Then there was an advertisement. Subsequent to that, 2025, another advertisement for those female candidates are concerned has been given. So there I also going to lose my chance.
2015 rules.
Yes, my lord, that's the, I mean, now they are following the 2008
nursing rules, recruitment rules of 2015.
Yes. And next page, my lord, that is at page 204. Volume 2.
Which rule you have challenged?
204. Page 204.
So it was given effect to Vide Gazette notification dated 27th April 2018.
My lord.
My lord.
So therefore, already 7 years have passed in the meantime. There is no scope for passing any interim order.
I am only before your lordship that I may or may not get chance subject to the policy of the government. It is one aspect. But so far 2025, what is going on, there is also I am losing my chance.
What can be done?
Their policy.
Well, unless until the virus of this rule is decided, there is no scope.
My lord. That's true.
Yes,
that's true.
In the writ petition, you have specifically challenged rule 2. Sub rule 2 under which rule?
Rule I think, my lord, amended portion.
Amended, but there is a page 204. Volume 2, 204. Page 204.
Yes, 204.
Now this is said the age between, well, may I place it, lordship? Well, age between 18 years to 39.
The said rule in the said rule in rule 5.
Well,
so it is amended rule 5 2.
Rule 5 2.
In the writ petition, amended rule 5 within sub rule 2. Sub rule 2. Which was brought into effect with a Gazette notification dated 27th April 2018. একবার সেন্টেন্সটা পড়ো তো না rule 2 of
West Bengal nursing
personnel within bracket recruitment, close bracket rules 2015, which was brought into effect with a gazette notification dated 27th April 2018 is questioned. Is questioned. Stop. Petitioners are aggrieved by.
Now, kindly indicate the male candidates, my lord.
Preference given
Well.
in favor of female candidates
In staff nurse, my lord.
Grade 2.
Recruitment of staff nurse, grade 2.
2.
That is at my lord. It will be clear, my lord, 202, if you lordship, see 202. Clause 4, staff nurse, grade 2.
Clause 4 of
202, my lord.
202, my lord. Page 202, clause 4, post has been mentioned. Staff nurse, grade 2.
is a method of recruitment. Just
Post, my lord.
Post, my lord.
This is the post.
Roman 1.
Name of the post.
staff nurse grade 2
My-
in recruitment of staff কি বলছিলাম in recruitment of staff nurse grade 2. Stop. Next paragraph. Next, state respondents are represented by learned advocates. Stop. Considering the issue involved in this writ petition and the nature of challenge thrown to a particular provision is to a particular provision as amended vide gazette notification dated 27th April 2018. There is no scope for passing an interim order. Stop. Issue, no, stop. Issue needs to be decided after calling for affidavits. Next paragraph, let affidavit in opposition to this writ petition be filed by 2 weeks after ensuing Christmas vacation. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter.
1 week.
By 1 week thereafter. Next paragraph. Petitioners shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
When I'm praying for leave to file one supplementary affidavit in the annexure portion, I read it wrong. My lord. That is, but P1, P2 I have referred, but annexure I mentioned A.
The over the supplementary affidavit filed on behalf of the petitioners is taken on
The
board.
copy has been served up in the state. My lord. I'm grateful.
In one matter, I have requested learned advocate general to appear.
Yes, my lord. Yes, my lord.
Yes,
No.
because there are no benches under West Bengal Administrative Tribunal. Now the litigants are coming directly before this court, which prima facie court has expressed view that if tribunal is not available in consideration of L. Chandrakumar, litigants or the petitioners are required to approach the Honorable Division Bench,
No, no.
not before the single
Single
bench of High Court. Now, the present judgment of Rogers judgment is being relied upon as a 5-bench judgment.
My lord.
So, tell Mr. Advocate General to appear on a particular date where
Probably it will be taken
after
up on
vacation. After
Fine.
vacation.
Okay.
Probably on 6th.
6th.
I'm grateful to know.
If in the meantime appointments are made, issue will be diluted.
Yes, ma'am.
Tribunal. Otherwise, court has to consider.
But considering that issue also, if there is only one member and the party will, my lord, give consent, they can move the.
Now they are submitting, there is no member. Yes.
Item number 3.
For
the response,
for
madam.
the petitioner, as per your lordship's direction, I have served to the respondent number
Six.
6 an affidavit of service. They have received.
Yes, what is the present position?
My lord, two, my lord, verification is required. One is from, my lord.
Have you obtained any?
Yes, my lord. Yes, my lord. One is from the Director Central Fingerprint Bureau. That is respond number 6.
That you have obtained.
That I have obtained. Then we have sent to the, my lord, respond number 4 before, my lord, the Central Forensic, my lord, Laboratory for, my lord, verification of the, my lord, fingerprints, my lord. So, my lord, if you lord, my lord, these are, my lord, I can show to your lordship the instruction here, my lord, on 22nd on my lord, 2nd February, 2nd December 2025, my lord, we have received the instructions from director of, my lord, fingerprint. Then, my lord, 3rd we have sent before the respond number 4. That is, my lord, awaiting, my lord. After, my lord, getting, my lord, 2 reports, we can, my lord.
When you will be able to produce the report from Fingerprints Bureau, you have
Received.
Now you have sent to the
Central, my lord, the Central Forensic Laboratory.
Forensic Laboratory.
Kindly fix, my lord, time limit, my lord, judicial order may kindly be passed, my lord, it will be, my lord, easier for us.
So why in all matters the judicial order is required to be passed? You obtain order or obtain report from CFSL.
Very well, my lord.
Central Forensic Science Laboratory you have sent.
Yes, my lord. Newtown. We have sent. On 3rd December. 2nd December we have received, and on the next day we have sent.
What is the report so far? Fingerprint.
My lord, original report has been sent, so report has not been sent to me, my lord. Only, my lord, instructions I have received that they have received the report from, my lord, the Central Fingerprint and then sent to the, my lord, Forensic Laboratory.
Forensic Laboratory is party?
Yes, my lord. Yes, my lord. Respond number 4, my lord.
So you are representing Forensic Laboratory?
Yes, my lord. My lord.
Yes, number 4.
4, my lord.
Issue. Mr. Ghosh, learned advocate representing Union of India on instruction submits that pursuant to the order dated 19th November 2025, Central Directorate, Central Fingerprint Bureau, National Crime Record Bureau, New Delhi, sent the report on 3rd.
On 2nd, my lord. 2nd February.
December 2024 to BSF.
To, my lord. Yes, my lord.
To Border Security Force, and said report was forwarded to CFSL.
My lord.
And the report and the said report and on receipt of said report, same was forwarded to Central Forensic Laboratory, Kolkata
on 3rd December.
On 3rd December 2025 for obtaining further report.
Obtaining for my lord handwriting and signature verification, my lord.
For
And
obtaining,
handwriting and signature verification.
for obtaining report after verification of handwriting and signature of the petitioner.
My lord.
Stop. Director, next paragraph, Director Central Forensic Laboratory, Kolkata, being respondent number 4, is directed to forward the report by fortnight from the date of communication of this order to border security force, as appointment of the petitioner for the post of constable GD depends upon such report, and petitioner is one of the waitlisted
withheld list.
with one of the candidates whose name is a candidate whose name is featuring in the list of withheld candidates. Next paragraph, learned advocate representing the petitioner is directed to communicate this order to the respondent number 4 by 7 days from date. Stop. Next paragraph, list the matter under the same heading for further consideration on 15 January 2026.
Get
Item number 4.
for the petition in this matter.
Yes, what is your instruction? You are appearing for the state response
report,
No, mere filing report will not do. ফেরত দাও. Now it is petitioner has been terminated from service on 7 by dismissal order dated 17th October 2025. Now the basis of termination is involvement of the petitioner in a criminal case, that is Manik Chowk PS case number 443 of 2016, dated 19th October 2016. Petitioner submits that the authorities proceeded on the premise, since one Imam Haq alias Imam Hussain was involved in the said criminal case, was implicated in the said criminal case, but said Imam Haq or Imam Hussain is not the petitioner. So what is the report to that extent? Tell me.
These are same and identical person, my lord. Son of Sheikh Duggi, what I could recollect this, my lord. Sheikh Duggi, my lord. His actual name is, my lord, Tajimul Haq. These are same and identical person, my lord.
Who are same identical person?
My lord, this Imam Hussain, my lord, son of Sheikh Duggi, as is in the FIR, my lord, and Imam Hussain, son of Tajimul Sheikh. My lord, these are same and identical person.
Yes, Mr. Lahiri, you demonstrated on last occasion that petitioner is not on what, based on which documents?
Yes, my lord. Kindly, my lord, first of all, I will show that page 32, this is the complaint copy. Possibly lordship had marked also.
Kindly see Imam Hussain, Pita Sheikh.
At the middle, Imam Hussain.
Imam Hussain Sheikh Duggi.
Pita Sheikh Duggi.
I am Muhammad Imam Haq, that I have stated in page 21 in my application form. Page 21, son of Muhammad Tajimul Haq. Now, my lord.
Just page 21.
Page 21. Kindly see. Name Muhammad Imam Haq. Father's name Muhammad Tajimul Haq. Is the petitioner before your lordship.
May the complainant in this.
Just.
My lord, before adjudicating, my lord, may I be heard, my lord?
Please wait.
I am waiting, my lord.
Yes, Imam Hussain Muhammad Tajimul Haq is the petitioner.
Muhammad Imam Haq is the petitioner, son of Muhammad Tajimul Haq. Now,
yes, Imam Haq is the petitioner. His father's name is Tajimul Haq.
Tajimul Haq. Now, my lord, kindly complaint copy Imam Hussain, son of
Duggi.
Now, my lord, in the FIR also, next page, same. Kindly, lordship, see the middle portion, right hand side, Imam Hussain, son of Sheikh Duggi. Next, my lord, kindly.
Page 37.
Page 37. No, page 37 is their report, which I am disputing. My lord, kindly come to page 44 once. Page 44, the Manikchok PS Malda gives a report.
When you were appointed?
I was appointed
22. 2020.
2023. 2023. I have appointment letter page 17. 28th of August 2020.
So it's a police verification report prior to appointment.
Yes, prior to appointment.
Okay.
Now, my lord, kindly see the court's record. In the bail order also, before the learned trial court, the name is Imam Hussain at page 43.
Page
43. Well, that person had obtained bail in that proceeding. Kindly see the last paragraph. Imam Hussain.
Yes, Imam Hussain.
Imam Hussain. Now, my lord, we obtained reports from the court itself, page 45 onwards. Kindly see. This is the official record we obtained from the court, page 45. Whether, question number 1, whether Muhammad Imam Haq, son of Muhammad Tajimul Haq, resident of village such and such, post such and such, Manikchok, PS Manikchok, district Malda, as is FIR named in connection with above referred case being such and such. Question at right hand side, extreme right hand side, serial number no. Serial number 1, no. Question number 2, whether Muhammad Imam Haq, son of Muhammad Tajimul Haq, such and such, is charge sheeted.
Now the point is, there was a police verification prior to appointment of the petitioner. Now in the police verification report, which is
44. Page 44.
Which is at page 44. Come to page 44. You don't have the brief.
My clerk is not here.
No. Actual matters wholly based on facts and without brief you are appearing. With a report from the police authority, please see the report. If this is the assistance the court gets, then it is difficult to adjudicate the issues, especially this kind, the issue, the nature of issue involved in this petition. First, state respondents were directed to appear. There's a notice, direction to serve notice. In spite of that, nobody appeared. Matter was adjourned, and today, state government, state advocate is appearing without brief. Come to page 44. Already there is a police verification because it's a case of 2016. Criminal case is of 2016.
2016.
You will get the criminal case. I have recorded in my order. PS case number 443-216. 2016 dated 19th October 2016. Is Manik Chowk PS case number. Now come to page 44. Manik Chowk PS Malda, what they are saying, please read it.
Further verification, it is certified that no adverse record could be found. Mohammad Imam Haq, son of Mohammad Tajimul Haq.
Now come to page 21. It is an enrollment roll and enrollment form of Border Security Force BSF. Page 21. Serial number 1, name of the petitioner Mohammad Imam Haq. And father's name Tajimul Haq. Come to the complaint.
Imam Hussain.
It is a complaint dated 9th October 2016, based on which this criminal case was initiated. 19th October 2016. Now it is complaint at the middle. Find out the name of a person, Imam Hussain. Pita
Sheikh
Duggi. Turns to next page. Turns on to next page. Page 33. FIR dated 9th October 2016 against clause 7, details of known, suspected, unknown, accused with full particulars. Then 8 reasons for under clause 7 it is stated Imam Hussain 20 son of Duggi, Sheikh Duggi. So how it was subsequently reported at page 37 by the Superintendent of Police Malda, DIB Malda, that petitioner is the same person against whom he is one of the accused in that criminal case which was initiated in 2016.
The complainant has addressed a letter to the DG BSF stating that this person is the same and identical person.
Complainant?
The complainant in the Manik Chowk PS, my lord. That complainant, my lord, had addressed a letter to the DG BSF stating that these two are same and identical persons.
And based on which petitioner has been terminated. Now, I want a specific report with regard to identity of this identity of the petitioner as well as Imam Hussain, son of Duggi, who is involved in the criminal case, who is implicated in the criminal case, and whether the petitioner and Imam Hussain is same and identical person. That is the crux of the issue.
Kindly come to page 37 for once. Father's name is not mentioned. Page 37.
For which state's presence court felt is necessary.
Kindly goes to the report once. My lord, here it is mentioned that they have the DIB, my lord, had examined few witnesses, my lord, and they stated that this is the same person, my lord.
Then why this police verification report was issued? Page 44. Come to page 44. No.
Appointment.
It is after the initiation of criminal case in 2023 by the same police station, Manik Chowk police station, officer ASI Manik Chowk police station.
That I have to take instruction, my lord.
Same police station, it's subject to further verification. It is certified that instantly no advance record could be found against Muhammad Imam Haq, son of Muhammad Tajimul Haq. And nowhere it is found that the name of the father is Sheikh Duggi.
The witnesses state otherwise, my lord. The local witnesses, my lord, they state otherwise, my lord. My lord, this person is locally known as Sheikh Duggi. And that's one of the reason, my lord, this complainant has named the father name as Sheikh Duggi.
Based on hearsay, I will be terminated.
Yes, so do you have a copy of this report so that you can place the relevant part of this report?
My lord. My lord.
No, another copy you have?
Yes, ma'am.
Yes, give me the report.
Last para, my lord. Examination of witnesses.
Who examined witnesses?
The DIB, the officer in charge of the DIB, my lord. DIB Malda.
Police DIB Malda.
Even the complainant has identified, my lord, what the DIB is stating.
Complainant may have some vested interest.
I don't know what.
Which vested interest against the person.
Just a minute.
Sir, page number page number 31.
The same Manikchuk case, our একটা report দিয়েছে। Manikchuk case has
another report of
another report.
Yes. We don't know how that ASA is given, but that same Manikchuk PS is given. That may also be taken into consideration. That was also taken into consideration. This is only kindly consider that, but other report same
Mother of the said petitioner, own name আছে তাজিমুল, wife of তাজিমুল হক.
Who is the investigating officer in the in the said case? But the case is pending. What is the present status of this case?
The next date is fixed for
because he will say that he doesn't know. He is not implicated in that criminal case. What is the present status of the criminal case of 2016?
Fixed for consideration of charge on 17th of February.
Consideration of charge. So therefore, the petitioner, if the petitioner is the same person who is implicated in the criminal case, he must have appeared before the investigating officer.
My lord.
So therefore, obtain a report from investigating
There is another report. There is
subsequent
obtain a report from investigating officer. He knows everything.
My lord, that must.
There is a
It is the end of the matter.
Subsequent report from the same Manikchuk case, my lord.
Subsequent police's subsequent report.
It is not required at all.
Manikchuk PS's report he has submitted.
It's not required at all because in the criminal case you are saying that I am not
the same person.
Same person who is implicated in the criminal case of 2016. Now, in support of such statements, certain documents are relied upon. Now, the thing is this: only question is whether you are implicated in the criminal case or not.
And who obtained bail also.
Already, matter is fixed before the trial court for consideration of charge. Charge sheet has already been filed under 173 of CRPC. Now, because it is 2016 proceeding. Now, if that be so, then the investigating officer is the best person to clarify whether petitioner is the same and identical person or not. Who is the investigating officer?
Only one thing, my lord. My learned friend submitted another report. The IC has said, kindly see once one paragraph. Another report has been submitted.
I will not see anything. After this,
kindly see the
let the investigation come.
My lord, may I submit, my lord?
Voter entry was found. Kindly see for once. May I request once, my lord? It's a factual matter. This next.
Yes, Miss Sinha. Who is the investigating officer? So far, the criminal case of 2016 is concerned.
Who is the investigator?
Rajkumar Mandal.
And my lord, the complaint said mistakenly name was given. Kindly
Yes,
see page 2. Mistakenly.
My lord, I am told it's Mr. Rajkumar Mandal.
What is his designation?
Yes, sir.
Volume.
Yes, sir. Yes, sir. Sub-inspector. Sub-inspector.
Sub-inspector of that police station, Manik Chowk, PS Malda.
Yes.
My lord, may I submit, my lord?
Why you are
I require
coming
to
in
be
the way?
required to be heard, my lord, because I am
At this stage, it is not required.
My lord, it
Whatever
is
you have
required,
done,
my lord.
whatever you have done, you have already terminated the petitioner.
But before in this
Let-
court, my lord, I have come. I am answering respondent.
I will consider
need to
it
be heard, my lord.
if it is found that the petitioner
My
and
only
and the-
contention is, my lord, this is an appealable order, my lord.
please hear this court. If it is found that the petitioner is the same person,
My
it is
my
an
contention
appealable
is
order.
that this court should not go into that matter,
Should not.
my lord.
No.
That
If
is
there
my
is a, if
contention.
there is a provision of appeal, then normally court do not exercise discretion
That is what.
to
Exactly.
entertain appeal. That does not mean
No, no.
that the writ court cannot entertain
No,
the
no,
appeal.
my lord
Entertain
can.
the writ
My
petition
lord can.
since
my
there is an appeal provision.
My lord can. My lord can. But I need to be heard.
Yes.
I needed to be heard. my
Very
lord.
basis is whether the person is implicated in the criminal case. What your appellate authority will do at this stage? Your very basis is this, that the person was implicated in criminal case. Whether the person implicated in criminal case is the same and identical person as the petitioner, who is an employee or who is working under BSF, that is the whole issue. If that is proved, then everything goes.
Then
If
nothing
that-
remains to be
Yes.
decided by the
So,
appellate
so
court.
therefore, don't take this point, Mr. Counsel, that there is an appeal provision that a writ court cannot exercise its discretion.
Can, my lord.
Normally, we
Doesn't.
do not exercise such discretion.
Yes, my lord. That is what my contention was.
Yes, but writ petition is maintainable.
My lord, my lord. My lord has that power. Inherent power does my lord.
They say the voter list is different.
Yes.
They say voter list name is different.
Nothing is required. I want a report from the investigating officer.
My lord, since
Why you are going here and there now?
there is a
Mr. Lahiri?
reason, because there is a dichotomy between their
Yes, yes.
in one report.
Yes, yes, Miss Sinha, who is the investigating officer?
Rajkumar.
Rajkumar Mondol. Where from you are getting this?
From the FIR, my lord.
There's no change in this.
So in the meantime, there may be a change. 2016.
Yes.
Obtain instruction that who is the investigating officer.
Based on record, they cannot.
I want a state report from the investigating officer, because this petitioner, if petitioner is implicated in the criminal case, he must have appeared before the investigating officer.
Whether he can override DIG's order.
Yes.
DIG
Court
has
can.
passed-
Court-
Court can
court
absolutely. Whether the investigating officer can
Yes.
override
Yes.
DIG.
Are you aware of? Are you in a position to apprise this court that who is the investigating officer?
Lordship, may I come back with instructions? Proper instructions, my lord.
Only thing court wants that who is the investigating officer.
Lordship, may I come back with instructions?
Issue.
They have already given it on writing, my lord. So I do not know whether there will be any difference, because the higher
Oh,
authority.
very well. Not today. Come back tomorrow.
My lord.
Obtain
Kindly ask some order, my lord. I am standing
obtain
here for 3
instruction.
days. Nothing.
Obtain instruction that who is the investigating officer. Miss Sinha, obtain instruction that who is the investigating officer. Come tomorrow.
My lord, tomorrow I will not be available, my lord. I will be there in court.
Your presence is not required at
It
this
is
stage.
required, my lord, because I am the
If
answering respondent, my lord.
ultimately, if it is found that they are same and identical person, then your order will remain.
Apart from that,
If it is-
I may have
please-
some other contexts.
Please
too,
hear
my lord.
this quote. If ultimately it is found that they are not same and identical person, then question would arise
Yes.
whether your termination order will survive or not.
My lord, I understand, my
In
lord.
that, at that juncture, your presence will be required.
My lord, I understand, my lord. State is accommodated, but I will not be accommodated. That is not fair.
Okay, your accommodation is, your instruction is not required. When your instruction will be required,
I am the
you
answering
are
respondent,
always accommodated. Please don't quarrel with the court.
I am standing.
Since
before-
no order is being passed
My lord,
today,
they are
which will
answering.
not inure to your benefit,
এইখানে?
My lord, at the
then
end
I
of
have to
the day-
tell the additional solicitor general
Yes.
appropriately. Yes. Please take your seat.
Report has been sent by SP.
Who is the investigating officer? Who is the investigating officer? I have seen this report.
Have you? Lordship.
Don't waste court's time. Who is the investigating officer? Are you in a position to apprise this court?
Change also.
Tomorrow, inform this court that who is the investigating
May
officer.
I come back with instructions?
Yes. Matter is heard in presence of the learned advocates representing the parties. Stop. A report dated 11 December 2025, prepared by Superintendent of Police DIB Malda, is filed in court today and same is taken on. Next paragraph.
Yes.
Issue, next paragraph. Issue is whether Muhammad Imam Haq, mananta EMAM HOQUE, MD tarage, son of MD Tajimul Haq, TAJIMUL HOQUE, is now Muhammad Imam Haq, son of so and so, and Imam Hussain,
IMAM.
son of Sheikh Duggi.
Check.
Sheikh Duggi.
Imam spelling is different. IMAM, not
IMAM.
IMAM.
IMAM, son of Sheikh Duggi, are same and identical person, is same and identical person, or they are different, is same and identical person or not. Stop. Petitioner in the present writ petition is MD Imam Haq, who has been terminated from service as it is found by the concerned as it is found by the concerned authority of BSF that he is implicated in a criminal proceeding being PS case number 443/2016 dated 19th October 2016. Manikchok PS case code. Stop. Next paragraph. Learned advocate representing the petitioners, learned advocate representing the state respondents submits that the criminal case to be considered by the court, the criminal case is to be considered by the court on 17th. What is the date? Next date fixed?
17th of
কবে ডেটটা বলে দাও।
17th of February.
17th of February. Where it is stated?
27th February 2026.
Where it is stated in the report? Second page.
Yes.
Which paragraph?
First paragraph. Continuing that. First paragraph.
ওইটা দেখাচ্ছে ছোটটা, বড় বড় রিপোর্টটা।
Report.
On 27th February 2025.
2026.
On 2026, yes, it should be 20. On 27th February 2026. Stop. Next paragraph. This court finds that investigating officer in Manikchok PS case number 443/2016 dated 19th October 2016 is in a position to apprise this court whether aforesaid two persons is same or identical person or not. Stop. Learned advocate representing Ms. Sinha, learned advocate representing state respondents, has paid for accommodation to apprise this court that apprise this court about the investigating officer in connection with the aforesaid criminal case. Stop. Hearing of this matter stands adjourned till Monday next, 22nd December 2025, for taking further instruction. Stop. Next paragraph. Client advocate for the state respondent shall also be at leave to obtain a report from the investigating officer before the next date of hearing.
I'll be relying upon their documents also. They have given all the Aadhaar card, voter card, everything. I'll be relying on that also. Grateful to Lord. Much obliged.
Item number 5.
Well, beg to appear on behalf of the petitioner, my lord.
Yes.
Pass over, your lordship. My senior is engaged in court number 12.
But,
Who is your senior?
June Kumar Mukherjee, Roy Mukherjee.
on the last occasion also, my lord, they had sought for an accommodation. There is some overwhelming urgency, my lord.
Whether you will oppose?
My lord, what I was humbly, my lord, submitting, my lord, may kindly consider my limited prayer, my lord. But just here's the
Sir,
fact.
pass over, let Rai Mukherjee
My
come.
lord, may kindly, my lord, hear the fact, my lord, once, my lord.
I will hear you, but
Then, my
not
lord,
now
kindly, my lord,
since the accommodation is paid
my lord,
for.
may kindly, my lord, keep it on Monday, my lord. So why I'll tell you, lordship, my lord.
Several matters
No,
are
this matter, my lord, is so urgent, but my junior was
tomorrow, today it will be taken up.
Yes, lordship, 10 minutes accommodation will do.
Third pass over.
Then, my lord, may kindly take it up at 2, my lord.
Original side
I
matters
have
are
a
there.
matter fixed at 1 o'clock.
At 2 original side matters. If you are not available, then you will be accommodated after original side matters. It will be taken up. Let me see.
But in that event, my lord, may it be taken up on Friday.
No.
আরে ভাই করে দাও না ভাই আমার প্রবলেম আছে
Yes, please call the next matter. Pass over. If you are engaged in other court, I will accommodate you.
Item number 6.
And for the respondent, my lord, as per your
The last occasion, your lordship directed to file the affidavit by
I'm filing
I have
short
not
affidavit.
received any copy. My lord, the relating to the recruitment of the CISF driver, just now he is handing over. My lord, the notification says
Oh, that matter.
yes, my lord. This is the
Yes,
my lord,
affidavit.
this is the trade test
Affidavit. I have given. Submitted.
notification with regard to the trade test.
In which paragraph you have stated?
regarding his certificate.
Yes. Regarding disclosing the reasons for declaring that petitioner is not qualified in the test.
Annexure R4, page 9, and here I'm
No, where you have made
yes,
the
yes,
statements.
paragraph 8. Paragraph 7 and 8 both can take.
7, just a minute. In page 9 where
Yes,
it is
page 9.
page 9 where it is stated that without wearing seat belt, without fastening seat belt, petitioner started driving.
Yeah, it is stated that I have been told about the grounds
Yes,
for my
that is-
rejection, and thereafter he put another signature. You see, candidates who have left the ground, that is matter. So he has put his signature that he has been told. Has been told about this.
Yes.
That notification I have handed over to your lordship. Kindly have a look at the trade test. There is a specific
Page number. Page number 10.
First of all, I want to use an exception to this affidavit because there are some allegation as per the law. Three stage of examination.
Yes, trade test.
First, driving of LMV, light motor vehicles, 50 marks. Pass marks is there. Then heavy motor vehicles, marks is 50. Pass marks is there. And then the knowledge about the car, particular vehicles, that is also marks. Where is the, may I put this question to myself?
How does it help you?
Yes,
Because
that-
you drove the car without wearing seat belt.
Yes,
That is impermissible in terms of the relevant provisions of the Motor Vehicles Act.
Motor Vehicles Act. I want to.
So how this will help
I
you?
want to
Clause
use
11.5 will help you.
that is the violation of traffic. Here, no traffic.
Whenever
is
you
there.
drive a car, you must wear seat belt.
I
at
have
the beginning.
never been allowed to drive the car. That is
where
my
you have
sole
stated,
allegation.
where you have stated in the
Yes,
writ
I
petition.
have, specifically, I have made this allegation. I just put the start key.
Yes.
Paragraph 7. That at the time of driving test, when your petitioner just on the key for starting the vehicle by pressing key of the vehicle and shift the rear gear of the vehicle, the respondent authority examiner asked your petitioner to get down from the vehicle. Specific allegation.
Yes, rightly said, because you started the vehicle.
But there is a time. I should not.
Before starting, there is a specific statement. Before starting, you need to wear you need to fasten your seat belt.
No, nowhere in the notification as well there is. Yeah.
What notification?
Notification
There-
for the
no
employment.
For that, no notification is required.
Yes, of course,
We regularly
because
tell our drivers
motor
wear the seat belt and then start the ignition.
No, my lord, my lord, I'm your order is subject to the correction of your losses. If I start a car in my house, there is no requirement for my lord,
No,
wearing
you are
the
not,
seat belt.
you are not driving the car in your house ground. It was a driving
That's why
test.
I want to,
So it was,
make an exception of this.
You are not
affidavit
driving your
filed in
car.
the file.
You are not driving your car in the courtyard of your house.
All right,
it was a driving test.
Yes.
So therefore, you are required to follow the procedure.
Yes, if I complete the test and they said that you are not wired the seatbelt, then I can understand. But here I just put the key and start. They get down from the car and rejected my candidature on that ground. I have not wired the seatbelt.
It is stated in paragraph 7. Accordingly, the petitioner started driving in reverse, but the said a motor vehicle inspector stopped the vehicle after reaching certain point as shown in map and asked the petitioner to get down from the vehicle.
Yes,
because you are not
that is why
wearing
last
seatbelt.
occasion they have produced the videograph that has not been
Shall I get the
produced.
videograph where he was starting and he was driving?
Malad, that is my instruction
So
of
why?
my client.
No.
Malad, I cannot improve that. Malad, I only can make an exception to this report because it is
That will not improve the
allegation is
position.
there, and I have violated the Motor Vehicles Act.
This is only to place on record the reasons relating to your failure in driving test. Nothing else.
Malad, that is
Therefore,
why
there is no question of any exception.
That is why I allege that this impugned order is non-speaking order. Here nothing has been mentioned. How I get the number, how much I get the number in the driving test, that has not been specified. This is a non-speaking order without assigning any reason, only driving non-qualified in the driving test. If I have not wired the seat belt and start the car and complete the test, then if they can reject it my candidature on that ground, stating that you have not wired the seat belt and drove the car.
Yes,
but that has not been done, my lord. That is my. I want to.
It is the post of driver in BSF.
Yes, my lord. That, not CISF, my lord. CISF. I want to use the exception to this affidavit filed by the respondent authority. It is my prayer.
Matter is heard in presence of the learned advocates representing the parties. Stop. Next paragraph. In terms of the previous order, dated 2nd December 2025. An affidavit, a short affidavit is filed. By the respondent number 5, affirmed on December 11, 2025, and same is taken on record. Next paragraph. At the next paragraph. In the affidavit filed today, it is disclosed in paragraph. It is disclosed that during driving test, Petitioner started the vehicle
And my lord,
started the light motor vehicle. Started the
section
light.
194B of the Motor Vehicles Act says that the penal provision.
Started the light motor vehicle. By pressing key without wearing seat belt. As a result whereof motor vehicle inspector had to abort a BORT. Driving test, as driving a motor vehicle, a light motor vehicle without wearing seat belt is impermissible. Stop. Next paragraph. On learned advocate representing the petitioner has relied upon clause 11.5 of recruitment of clause 11.5 of notice relating to recruitment of constable / driver and constable / driver cum pump operator within bracket driver for fire services close bracket in CISF 2024 wherein it is provided that who qualify in the physical efficiency test, physical standard test and document verification will be put through the following, driving test for light vehicle, driving test for heavy vehicle, and practical knowledge of motor mechanism and ability to carry out minor repair or vehicles. Stop. Any candidate who does not, it is also provided therein that any candidate who does not secure the minimum qualifying marks in these tests shown against each will be, now in these tests shown against each in these tests will be eliminated from that particular stage by issuing a rejection slip and will not be allowed to participate in the further recruitment process. Stop. Stop. It is contended that since petitioner was not permitted to complete driving, was not permitted to complete light vehicle driving test, question of allotting marks does not arise, and acts and actions of the respondent authorities are contrary to clause 11.5.1. Stop. Next paragraph. The provisions as contained under clause 11.5.1 does not come in aid of the petitioner as the petition, as the driving, as light motor vehicle driving test had to be aborted by motor vehicle inspector since petitioner started driving by pressing key without wearing seatbelt. Top. Next paragraph. Moreover, based on case made out, court was considering previously the document dated 12 November 2025, whereby petitioner was disqualified in driving test, does not bear reasons. But it appears that petitioner signed at the bottom of the said document dated 12 November 2025, certifying that he was told about the grounds of his rejection. Next paragraph. Since purpose of filing affidavit on behalf of respondents in terms of the order dated 2nd December 2025 is to disclose reasons as to why petitioner was disqualified in light motor vehicle driving tests, court finds there is no necessity to file exception to this report. সেন্টেন্সটা কি বলতো না? না, বাকিটা কেটে দাও। হ্যাঁ, filing of exception to this report is not called for, though prayed for. Top. As it is as it is averred in paragraph 7 of the writ petition, that when the petitioner pressed the key for starting light motor vehicle and shifted the gear, respondent authority / examiner asked the petitioner to get down from the vehicle, which corroborates the statements made on behalf of the respondents in the affidavit, which corroborates statement made on behalf of the respondents in paragraph 7 and 8 of the writ petition, paragraph 7 and 8 of the affidavit, which is filed today on behalf of the respondents. Stop. Nowhere in the writ petition it is averred that petitioner, after fastening the seat belt, FASTENING, fastening the seat belt, started the light motor vehicle during driving test. Stop. Therefore, calling for exception to this, to the affidavit filed today, will not improve the case of the petitioner further.
The Motor Vehicles Act does not show.
Next paragraph. Hence, no relief can be granted to the petitioners. The writ petition stands dismissed.
Deep level. Get But may I get back the notification?
Yes, you will get it back after putting signature. Yesterday's matter also, I directed my PA. You will get it back because there are certain corrections. That's why it was. Give it. Yes, next.
7.
Matter relative family pension of unmarried daughter, Lordship.
Working where? Where employee was working where?
West Bengal State Electricity Distribution Company Limited.
West Bengal State Electricity
Distribution Company Limited.
WBSCDCL.
Yes. She retired in the year 89. And
Now also, now you are also doing matters relating to WBSCDCL. Started doing matters.
pension matter. For
Yes. Yes, yes. What is the matter about?
father died 27th December 2000. Thereafter, Lordship, mother died.
Family pension in favor of daughter, unmarried daughter.
See,
Yes, yes. Father died on
Lordship 27th December 2000.
2000.
2000. Mother died, Lordship.
When retired, father?
Retired 89.
Date?
Date is not mentioned, Lordship. In the year 89.
Date is not known. Then father was receiving pension.
Yes, Lordship. And
then mother, when mother died?
Mother 8 April 2017.
8 April
2017.
2017. After death, you are receiving, you are claiming pension.
Yes, yes, Lordship.
When he made application?
Lordship, immediately after death, but I have deposited the application. I did not have the copy, Lordship. But come to the page 27. First rejection order, Lordship.
So rejection order is there.
Yes.
Page 27.
Page 27. Got it, Lordship?
Public Service Regulation 1985. Yes, 2021 order.
This was not challenged.
Lordship, I have challenged. I am coming thereafter, Lordship. Thereafter, I have also applied family pension and I deposited the income certificate. And that also rejected, Lordship. Come to page 33.
No, it says that under DCRB regulation 1985, you are not entitled.
Therefore, also come to
Well, so therefore, the respondent authority did not request to submit documents.
Yes,
It was not due to failure on your part to submit documents. It says that under DCRB regulation, you are not entitled.
Lack of knowledge of petitioners, obvious. Maybe, Lordship, the office told her.
Whether this was challenged?
Yes, Lord.
When it was challenged?
Next was Lordship, come to the PR, Lordship.
Page 26.
So in this writ petition, you have challenged.
Yes,
2021 order.
Setting aside the memo dated, Lordship, both memo, Lordship.
After 4 years,
Yes, Lord.
already your claim has been rejected. So let it be decided on affidavit.
Again, rejected, Lordship.
Another rejection order is there.
Yes, yes,
Where is that?
That is the page 33.
Previously regretted by letter dated 21st October 2021. It's not nothing but a reiteration of the previous order.
Yes, Lordship.
The claim upon review it is met standards previously.
My income is, Lordship.
Why petitioner will not get unmarried family pension being unmarried daughter?
2021, our regulation at that point of time, at the time of the death of the mother of the petitioner, 2,600 was the limit to be eligible to be granted pension. Now, that point of time, the document demonstrated by the petitioner that she was having 3,000 rupees. No, she was not eligible. That was communicated.
So mother was not getting pension.
Mother was getting pension, but the unmarried daughter.
Yes, minimum maximum the income limit was 3,000.
3,000.
Now it has been enhanced to 9,000.
9,000. That is with effect from 2022. That amendment was made in the rule. Now she wants to have a retrospective effect of that particular. That is not permissible.
Retrospective effect
of the amendment of the rule. That was done in that 2022. 2021, she was not eligible because she was having 3,000 rupees. And admittedly, 2,600 was the limit. Yes, it was
2,600 was limit.
That
not 3,000.
Not 3,000. So that was rejected in that 2021. Now, after the amendment, now taking...
But that is not spelled out in the rejection order of 2021.
That is not spelled out. Now, DCR...
Now, what is the reason assigned? What is the reason assigned?
Reason
assigned is that cannot be accepted as per DCRB regulation 1985.
That is
because income cap was 2,600. And if it is above 2,600, then the candidate is not entitled to get. Now, where is the reason given?
That is not there. That is not there. I had a talk with my officers, my lord. That is not there.
No, nothing.
My lord, if you want, my lord, we can my lord, give an elaborate, my lord, explanation for rejection of her claim. That we can do. Lord, she can direct, my lord, we can, my lord, supply. But my lord, the rule is very
clear. And the second communication dated 30th May 2025 is the reiteration of the previous order.
Because the case was being considered, my lord, on the rule.
Now it has been enhanced from 2,600 to 9,000.
9,000. That is with effect from 7th July 2022.
9,000.
9,000.
From 7 July
2022.
And rejection order Lordship 2,000.
What is the present income of the petitioner?
Present
3,000.
3,000.
So now petitioner is entitled.
But my lord, the case is being, my lord, taken note of, my lord, with effect from the death of the mother when she became eligible. The rule that was prevailing at that point of time, that was made applicable, and 2020 it was rejected. That was not challenged.
But if subsequently the family income, if subsequently income of the applicant is enhanced, it remains same, and the higher limit or income limit is enhanced from 2,600 to 9,000, why the candidate will not get
eligibility?
At that point of time, she might not be, might have been found to be not eligible. Yes. But now she is considering the enhancement. Why her case will not be considered?
Eligibility started.
Show me the provision.
Well, her eligibility started from the date of her mother.
Yes.
So, my lord,
court is not saying that you pay family pension during the period when the limit of family income was 2,600.
Yes.
But after enhancement with effect from 7th July 2022, why petitioner will not get?
Lordship, kindly may place, my lord,
The amendment order Lordship.
Till she is unmarried daughter.
Yes. Lordship, kindly see, my lord, page 19. Rule 19.
Also, I have annexed.
You have annexed?
Yes, sir.
Where it is?
Rule 19, I have annexed.
देखिए बोइटा दाओ.
Amendment also annexed.
Respect of pension. So unmarried daughter beyond, it is beyond the age of, age is above 25.
Yes.
Unmarried daughter beyond 25 years of age will be eligible for family pension subject to her income being less than 2,600 per month from all sources till marriage or death, whichever is earlier and thereafter. Now, if the income subject to the income being less than two, if the income limit is enhanced from 2,600 to 9,000 rupees, then subsequently petitioner should be made eligible.
But my lord, her eligibility, my lord.
No, that is not in perpetuity.
But my lord, in fact, my lord, the
court will not direct you to pay ADR benefits when 2,600 was the was the limit. But after enhancement from 2,600 to 9,000 rupees, petitioner is entitled to get.
No, my lord. So far, my lord, the amendment to the rule is concerned, my lord. The amendment, my lord, my respectful submission, my lord, will decide it, my lord, whether, my lord, any amendment of the regulation, my lord, can have any retrospective effect or not.
Court will not give any retrospective effect. Court will give it prospective effect so far the payment of family pension is concerned.
Her eligibility arose on the death of her mother.
Yes, but that is not crystallized in view of the subsequent enhancement. It is not a case of appointment on compassionate ground. It is a case of family pension which is required to be interpreted liberally. What you are submitting?
True, my lord. But my lord,
it's not a case of appointment on compassionate ground, Mr. Chattopadhyay.
I appreciate, my lord. I appreciate what is following from my lord, my lord. But I had a talk with my officer, my lord. The difficulty is, my lord, in that event, my lord.
It's a beneficial scheme. It requires to be interpreted liberally. Otherwise, whole purpose of enhancing the limit from 2,600 to 9,000 will be defeated.
No, that will be made applicable, my lord, eligible, my lord, the persons who died after the, my lord, amendment came into effect. The persons who
think about the position
There is no
that,
mention, Lord.
please wait. Think about the position that from 7 July 2022, on 10 July 2022, if an unmarried daughter's family income is per month is 5,000 rupees, and another daughter's income is was 2,600 rupees or less than that. Both will get, but there will be another class of unmarried daughters that, since their case was decided prior to 7th of July 2022, they will not get family pension. But similarly circumstanced other group of unmarried daughters or widowed daughters, they will get family pension since their entitlement was considered after 7th of July 2022 on the anvil of enhancement.
But my lord,
it doesn't make any sense.
No, true, my lord. But my lord, what?
And also in the state government, other department, you obtain instructions. This point is never urged after enhancement.
Let me come back on Monday. Let me take instruction. Let me come back on Monday. My lord. I'm getting, my lord, the points taken by your lordship, my lord. The difficulty is, my lord, in that event where the floodgate will open.
Yes, those who are entitled to get, they will get it.
My lord, let me come back.
Otherwise, the purpose of enhancing the limit from 2,600 to 9,000 will be defeated. No. And the court is not considering appointment on compassionate ground. That the scheme which was prevalent on the date of death, and now it is at the time of consideration of application after the law laid down by the Supreme Court, that will be considered. It is a case of pension, family pension. It has to be interpreted liberally. It's a beneficial scheme.
Let me come back, my lord, next month. Let me come back. I will, definitely, I will, my lord, take instruction, my lord, as to whether, my lord, what is the situation in the other state government.
Ask Mr. Mukherjee. He regularly appears before the state government whether this point is taken in case of teachers and other employees, that after enhancement of family pension, after enhancement of limit, from the date of enhancement, eligibility is fixed or considered.
Let me come back.
What about the teachers? Same thing. It was previously 3,000, now it is 9,000, and those who had the income of 9,000 or less, they are getting pension after an enhancement.
But my lord, to become eligible, there should be, my lord, a cut-off date. Cut-off date is the date of amendment to the of the rule.
Retrospective effect can, yes, it does not have retrospective effect. That does not mean that from the prospectively it will not be applied.
But her
Court will not direct that from 2017 to 27th of July 2022 you will pay the arrear benefits. But from 7th July 2022, petitioner's entitlement comes.
No, my lord, my difficulty is, my lord, her eligibility, my lord, I'm
Sure.
sorry for repetition, my lord. Her eligibility comes, my lord, after the date
Petitioner
of the-
has affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Petitioner has claimed family pension being unmarried daughter of a deceased employee of West Bengal State Electricity
Distribution Company Limited.
WBSEDCL, just a minute. West Bengal State Electricity Distribution Company Limited, within bracket for short WBSEDCL, close bracket. Stop. Father of the petitioner was employee of WBCDCL who died in 1989 and who retired in 1989 and died on 27 December 2000. Stop. Father was in receipt of pension till the date of his death. After death of father, mother obtained family pension. Mother received family pension till her date on 8 April 2017. Stop. Petitioner being unmarried daughter and whose age is above 25 years is claiming family pension from the date following the date of her mother. Stop. Next paragraph, Mr. Supriyo Chattopadhyay, learned advocate representing WBSEDCL, submits that previously income limit was rupees 2,600 for adjudging an applicant whether to get family pension or not. Stop. From 7 July 2022, monthly income limit was enhanced from 2,600 to 9,000 rupees, 2,600 to rupees 9,000. Stop. According to the petitioner, according to the respondents, entitlement of the petitioner is required to be adjudged on the date of mother, that was on 8 April 2017, when income limit was restricted to rupees 2,600 and petitioner had income more than rupees 2,600. Stop. Next paragraph. Question arises for consideration that after enhancement of income limit, monthly income limit from 2,600 to rupees 9,000 from 7th July 2022, whether petitioner is entitled to receive family pension as her monthly income is less than rupees 9,000. Stop. Next paragraph. Mr. Chattopadhyay has prayed for accommodation to obtain instructions. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 7 January 2026. Take it back.
Yes,
I'm coming.
Milord, the passed over matter, Milord, item number 5, Milord. Mr. Rai Mukherjee is here.
Yes, original side mentioning.
My lord, may I mention one matter for inclusion?
Original side.
Yes, madam.
Original side. Yes, inclusion.
Was filed on this matter filed on December, but still did not come up in the list.
It will appear. It will appear just after or very well in next. What is the urgency?
The urgency is that the petitioner has been illegally terminated from his service without granting any opportunity.
When terminated? You do not know, and you are saying it is urgent. If the petitioner was terminated in 2021 and you have come after 4 years, how it is urgent? So let it appear in the combined monthly list of January 2026 under the heading court application.
Lord, may I permit to mention, my lord, in the last occasion, my lord, I have mentioned for extension of time of filing of affidavit in opposition. And lordship has
that matter is already fixed for hearing on 6th January.
7th January. 7th January.
7th January. You renew your prayer on that day.
Lord,
that's why I am directed not to appear in the meantime.
My lord, may I file affirm the affidavit, my lord?
That you can affirm and bring the affidavit on the next date. Court will consider.
Yes, much.
My lord, may I have your lordship leave?
Original side?
No, my lord. It's
mention on at the morning.
Well, it's from the determination of minor justice.
Maybe I mention in the morning. I am allowing everybody from determination. Not now. It is not the time to mention. I have allowed everybody to mention in the morning if it is from the determination of Justice Sinha.
I am permitted to mention one.
Don't mention.
Application earlier I am registered. It was your lordship directed to appear on monthly list of December, but till that is not appear, my lord. Restoration application.
Restoration application original side.
Original side.
Dismiss for default.
25th 7, my lord. Within time I.
25th July.
Of 25.
25. Within time you have filed. Next Wednesday.
Yes, madam. I'm granted.
May I have my lord's kind leave to mention a original side matter of 2024, although there was a direction to file affidavit by the respondent. Thrice it was extended. Affidavit has not been filed. My lord, for the pendency of the writ petition, I have challenged the initiation of the charge sheet. The charge sheet has been issued by a person who is not my appointee, rather very below the rank. But for this pendency, my benefit cannot be released.
Hearing matter, wait for some time. Now I am not.
Let it appear in the monthly list.
No. I have disallowed others mentioning of others. For the list.
Item number 1. But this item number 1 is identical to a matter which I have mentioned before your lordship of 2024, where several orders have been passed. And identical to the extent that it relates to the pay fixation of a contractual employee pursuant to the memorandum issued by the state government, which has been extended to the state transport undertakings also. But several orders have been passed in earlier writ petition,
Just a minute, let me see what was the order.
But I appeal for the Calcutta State Transport.
That I know. Last occasion I directed to serve notice. They to serve notice upon the state respondents or the learned advocate representing the representing the respondents.
I tendered unqualified.
Where is the notice?
I tendered unqualified apology, perhaps I have missed it.
Yes, sure.
Kindly grant me one question. It will appear after vacation.
Learned advocate representing the petitioner has paid for accommodation to serve notice in terms of the order dated 3rd December 2025. Stop. Hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of January 2026.
Notes.
Number 2.
Number 2, your lordship, Mr. Parthok is appearing in this matter, your lordship.
Yes.
He engaged in courtroom number 29, your lordship.
Pass over. Tell him to come.
Lordship, item number 2 to 5, your lordship. Yes,
Lordship, in item 4, I am appearing. Item 2, I am appearing, your lordship. Item 4, my impediment has been that, your lordship, I had original affidavit in opposition. A report was affirmed.
On the last week, I could not appear, and the same was kept in the court records, courtroom, and somehow that has been misplaced. So that I have to reaffirm the affidavit. That
Very well. When matter will be called on, you renew your prayer. 2 to 5.
Yes, your lordship.
Ask him to come.
Lordship.
Item number 6.
Lordship, my senior is engaged in another courtroom, praying for short possible.
Who is appearing?
Akashdeep Mukherjee.
Where is he?
He's another courtroom. He's coming.
Tell him to come. Pass over.
Item number 7.
My lord, I appear for the respondent. But here, my lord.
7.
6, madam.
6. Very well. Call item number 6.
Item number 6.
But this is the second round of the his mother was the applicant for the on the basis of the no objection. He made an application for the compassionate appointment. He was given the compassionate appointment, but the nature of that was contractual. Initially, he was engaged. Thereafter, Lordship, we filed one application before this court. The Honorable Justice.
Just a minute. There are the our orders. Just let me go to the.
Lordship, kindly come to.
Just a minute. Huh?
Kindly come to page 41.
40.
40. This was the order passed by the coordinate bench in the first round of the litigation. And this will give the entire picture. The father of the petitioner was an employee of respondent number 2. The father died on November 29, 2007. During the tenure of his employment, the mother of the petitioner, being widow, first applied seeking compassionate appointment. The application was not considered and kept pending. At this juncture, the petitioner, being the son of the deceased employee, applied seeking his appointment as compassionate appointment. Document at page 17 to the writ petition dated February 15, 2011 shows the application of the son, being the petitioner herein, was under process and the authority was insisting of that. The petitioner was ultimately given an appointment as a contractual conductor, but not against any sanctioned post. The record shows that no final decision has been taken by the authority with regard to the application of the petitioner for compassionate appointment. Relying upon the order passed by the coordinate bench dated April 27, 2022 in WPO 1240 of 2021 in the matter of Upendra Kumar versus State of West Bengal and others, such and such learned counsel appearing for the petitioner submits that under the similar fact situation, the coordinate bench directed the respondent number 2 to consider the case of the applicant seeking compassionate appointment along with the consequential directions, as would be evident from the order. Such and such prays for the disposal of the writ petition in the same light as that in the matter of Upendra Kumar Supra. Respondent number 2 are not represented. This court, in the facts of the case, is of the opinion that by keeping this writ petition pending, no further fruitful purpose shall be served. Accordingly, the following directions are made. The petitioner shall serve a copy of the entire set of the writ petition with annexures along with the copy of today's order upon respondent number 4. Respondent number 4 then, upon issuing prior hearing notice or of at least 7 days to the petitioner and after granting him an opportunity of hearing, shall decide the issue by passing a reasoned order in accordance with law. The entire exercise shall be carried out and completed by the respondent number 4 positively within the period of 6 weeks from the date of communication of this order, and the reasoned order shall be communicated to the petitioner within a further period of 1 week from the date of the said reasoned order to be passed. It is made clear the court has not gone into the merits of the claim of the petitioner and the merit of the writ petition. The petitioner shall be at liberty to urge whatever point he wishes to urge by relying upon whatever records, documents, other wishes to rely upon before the respondent number 4, but the same shall not travel beyond the scope of the case made out in the writ petition. In the event reasoned decisions goes in favor of the petitioner, the appropriate authority shall give immediate effect thereto, but positively within a period of 6 weeks from the date of the said reasoned order to be passed upon compliance of the necessary formalities. It is needless to mention, my lord, this is important, needless to mention that while deciding the issue of the respondent number 4 shall also consider the order of the coordinate bench in the matter of Upendra Kumar Supra and their subsequent decision, which are made in part of the writ petition. From the document at page 29 of the writ petition, it appears that respondent number 2 has already acted upon the said decision of the coordinate bench, since affidavits are not called for allegations such and such. Whether this was done, then Lordship kindly come to page 45. Hearing was conducted.
Yes.
Kindly come to page 46. So, Lordship, that was the direction, and in the light of those directions, this authority was required to dispose of my case. Page 46 is the hearing on 25/7/2025 in compliance with the direction passed such and such. 4/8/2025 in compliance with the direction of the His Lordship, the Honorable Justice Aniruddha Roy, dated 22nd May 2025, passed in.
But I'll not disturb my learned friend. Only thing, my lord, since he's placing the impugned order at page 46, my lord, when it was served upon his client, my lord, it was our mistake. Lordship will find that possibly in Lordship's brief also it contains only 2 pages. The middle page was not served upon him by mistake. Subsequently, it has been served. He has got a copy. My lord, I'll request your Lordship to go through this, which will, because this is not the full order. The middle page, I do not know why it was not served. It was missed.
That was served later on.
Yes, yes, but before moving out. So, it place kore lao.
After receiving the contempt.
Contempt abar kena hobe?
Mr. Biyani.
Apni to page is.
Compliance with the direction of his Honorable Lordship, the Honorable Justice Aniruddha Roy, dated.
Now, where is the scope of passing interim order?
But Lordship, kindly, there is a scope of disposing the writ petition in view of this, because Upendra judgment is very clear that what is to be done. It is respect of the same Lordship body, that is the CTC. Now, the argument they have placed here, possibly Lordship can find out, if your Lordship read Upendra.
Coordinate bench directed that Upendra's judgment would be considered.
That was not called. In Upendra Rai, what happened? The same facts, same similarly placed candidate was considered for the purpose of the compassionate appointment. So they accepted there was existing scheme for compassionate appointment that was given, and this was also, Lordship, kindly come to page 31. This judgment is there.
But you were also given appointment on compassionate ground, but not against the substantive post.
That was decided in the Upendra's judgment, and ultimately Upendra got the job in the against the sanctioned post, against the permanent vacancy. That was the full play, because the main argument there, which was considered by this court, was that the scheme, where there is a scheme for the compassionate appointment, it should be, Lordship, against the permanent vacancy sanctioned post, not for any contractual vacancy. That was the, Lordship, kindly come to page 31. This is the judgment of Upendra. That gazette notification after Upendra. This was the gazette notification. Lordship, whereas in pursuance to the labor departments, the governor is pleased to formulate the policy. This is the policy. And
it was considered in Upendra Rai. This notification. It is a notification dated 13 January 2011.
That was the scheme
of the transport department.
And this is the judgment, and it is handed over.
Well, page 32 is the notification after Upendra.
32 is the
after
letter to Upendra of pursuant date.
This was considered by them. 32. Whereas the Honorable High Court, Calcutta, in such and such decision, directing the state to consider the petition. And whereas the Honorable High Court Calcutta has been pleased to issue Sir Vinod Kumar, the Principal Secretary, Transport Department, such and such, whereas the West Bengal Transport Department, Lordship kindly straight away come to last paragraph.
Page 32.
Page 32. 1, 2, 3, 4, 5. Paragraph 5 onwards. And whereas on 19th May 2023, the Honorable High Court Calcutta has been pleased to direct the Managing Director, West Bengal Transport Corporation, to issue fresh appointment letter in favor of the petitioner after deleting the portion that the appointment is subject to the result of this an appeal. Now, therefore, pursuant to the solemn order dated 19 May 2023, passed by His Lordship, the Honorable Justice Arindam Mukherjee, in respect of CC 60 of 2022, with WPO 1240 of 2021, you are hereby appointed conductor in regular cadre with effect from 18/5/2023, forenoon, under control of the Deputy Managing Director, Tram and Bus. You will be entitled to the pay scale such and such. Now, this was passed in pursuance to the order of Upendra Kumar. Now, in my case, that was not considered. May I read the reasoned order passed by them? Lordship, I am invited to Mr. Bihani that he has handed over me the copy of the entire copy. But I was not served, admittedly.
They subsequently served, but when you both.
May I read it? In compliance with the direction of His Lordship, the Honorable Justice Aniruddha Roy, dated 22nd May 2025, passed in WPO 1336 of 2023, the matter was taken up for the consideration. The petitioner Sri Joydash was heard in person. The petitioner contended in his writ application that his father was an employee of CSTC and expired on 29/11/2007. At the time of the death of his father, he was a minor. Therefore, his mother, Srimati Deepa Dash, applied for the appointment on compassionate ground. He alleged that he made several correspondences, but he was not offered any employment on compassionate ground. But there is nothing to show as to when and how the writ petitioner submitted his application for appointment under compassionate ground in writ application. He submitted that in June 2020 he was appointed as conductor in CTC through agency. He cited an instance of the appointment of Upendra Kumar in West Bengal TCL CTC on compassionate ground. He thus prayed for the appointment on compassionate ground on a permanent post. It appears that there was a compassionate appointment made in CTC at the instance of a court order dated 27/4/2022, passed in WPO 12401 of 2021, and that too was under the direction of the Government of West Bengal in Transport Department. In the writ petition is stated and contended that the respondent number 2, a government company registered under Section 617 of the Companies Act 1956, that is out and out a misleading statement. The father tried to mix the West Bengal Transport Corporation Limited with Calcutta State Transport Corporation, which are two separate legal entities. The Calcutta State Transport Corporation was never been transformed to West Bengal Transport Corporation Limited. However, it transpires from the records, at least till 9th April 2003, there was no scheme for compassionate appointment whatsoever in the corporation. It was pertinent to state that any such scheme would be framed and or floated or approved by the Transport Department, Government of West Bengal. It reveals from the record that the Government of West Bengal Transport Department, by its memo number 1345 WT dated 9/4/2003, as one-time measure conveyed its proposal for employment on compassionate ground against the die in harness category only for certain specific number of enlisted candidates seeking appointment of compassionate ground under die in harness category. With the passage of time, after absorption and or offering those candidates appointment on compassionate ground in the corporation, the said one-time approval and or the said one-time scheme for compassionate appointment does not exist, but that as it may accept such a one-time approval for the appointment of the corporation against a specific number of candidates in die in harness category, neither at the relevant time at the present moment there is any scheme for appointment on compassionate ground, either on dying earners category or in any other category in the corporation. Undoubtedly, the objective of granting compassionate appointment is to financially assist the bereaved family and provide immediate succor by averting the financial crisis that the dependents and the deceased employee may face due to sudden death of the breadwinner of the family, provided that is scheme of such employment on compassionate ground. In fact, the Labour Department, Government of West Bengal, filed notification number 251, dated 3rd September 2013, withdrew and or superseded its all previous orders or notifications regulating the appointment of the compassionate ground, and thereby restricted the scope of such scheme for compassionate appointment. In 2013, by issuing a notification number 251, it has been specifically mentioned that the scheme for compassionate employment is only for the employees of the state government department, and all the earlier notifications issued for compassionate employment have been superseded by its notification of 2013. In fact, there is no scheme after 2013 in any manner whatsoever in CSTC or any of the STUs. As such, in absence of scheme, prayer for compassionate appointment cannot be exceeded. It is pertinent to mention.
Yes, where is the scheme?
Now, there is this scheme. Lordship, kindly come to page 19.
Because you were appointed in CTC, Calcutta Tram Company. That is through agency. It has got nothing to do with the
Not CTC, CSTC.
Calcutta Transport Company.
He was appointed in CSTC. Upendra Kumar Roy was in CTC.
In
June 2020, he was appointed in CTC. It is stated the read petitioner submitted his application for appointment under compulsion. First page, second paragraph.
Yes. Lordship, this is.
He submitted, and in June 2020, he was appointed as conductor.
That was his submission.
CTC.
CTC. Actually, his appointment is in CSTC.
Calcutta State Transport
Upendra Kumar Roy's case, he was an appointee, he was an employee of CTC.
There cannot be any
No, let him complete. Let him complete.
No, but what is the scheme? If there is no scheme, question of appointing compassionate on compassionate ground does not arise.
Page 19. Once. Lordship, kindly come to page 19, Calcutta State Transport Corporation. This is dated 2011 with reference to his application for employment in CSTC. Page 19. With reference to his application for the employment in CSTC.
Just on. Yes.
This is dated 15 to 2011. My lord, then kindly come to page 31.
Where is your application for appointment on compassionate?
Application was there, that's why it was considered. This was issued.
Now, what was your age on the date of death of the employee?
That looks well.
In 2007, expired on 29th November 2007. What was your date? What was your age?
My today, his age is
32 years at present. At present, 32 years in 2007.
My mother applied first
So
initially.
show me that you have a right being minor.
The mother applied, my lord.
Maybe mother had the right, but a minor on the date of death, unless scheme provides, you have no right.
Yes,
Show me the scheme. Under the scheme that a minor has got a right.
Kind page 31, my lord. This is dated 13/1/2011. This is the scheme. That's why, lordship, I referred to.
How that is applicable? when employee died in 2011.
But kept pending, application was kept pending, my lord. Application was kept pending.
Application of mother kept pending. Show me from the scheme.
That's why I'm reading.
Yes.
May read. Whereas the pursuant to the Labour Department notification number 142, employment such and such, government is pleased to formulate the policy with the prayers of the appointment of the financial assistance on compassionate ground received by the state transport undertaking from the dependents of the employee of STUs. STUs who die in harness.
Please take me to the relevant provision where no, please don't read the entire thing. Please take me to relevant provision from where it can be construed that the minor on the date of death of the employee, minor son or daughter is entitled to get appointment.
May I kindly come to page.
This is the division bench judgment on this issue. Yes.
Page 34, man. Okay. Page 35, 7. The dependent of the employee seeking appointment on compassionate ground shall hence make an application in prescribed form.
35, 7.
Deceased employee is retirement on the permanent if no application is submitted within the stipulated period, it will be presumed that a family does not require immediate financial assistance. On receipt of such application, the appointing of the organization shall form inquiry committee, senior officials not less than 3 in number. The committee will form a condition as invested CD in Labour Department notification will be fulfilled for the appointment. The organizations have to keep their hands strictly. Lordship, this condition, Labour Department notification.
Show me the provision that on the date of death, minor has the right. If the dependent son or daughter is minor, he has right to be considered for appointment on compassion.
Lordship,
please
they
show me.
Kept it pending.
I want a provision in the scheme granting, conferring right upon a minor son and daughter to be appointed on compassion ground. There is a judgment by the division bench presided by Justice Dotto that on the date of death of the employee, if son or daughter and dependent or any eligible dependent member is minor, he has no right unless scheme provides. Show me the scheme.
May I consider the judgment and come back?
It's not necessary. Subsequently, I authored a judgment sitting with Justice Dotto, Azim Gaji on the same point.
May I come back?
Yes, no, you show me from the scheme. I asked you that what is the provision, where is the scope of interim order?
Yes,
you have already argued for last 25 minutes. You show me from the provision that there is a scheme.
Yes.
So you show me from the scheme that there is a provision that a minor has got a right to be considered for appointment on compassionate ground.
I made an application in 2011 when I was major.
You are major in 2011.
2011, that's why I made the application. That was this letter was addressed, my lord, to me.
No, please calculate if today your age is in 2025, 32 years, then in 11, 32 years, then 32 in, if it is 30, the employee died in 2007. Yes, 29 November 2007. Then your father died 23 and 2, 25 years before. So 32 minus 25.
25 years.
Yes, employee died, employee expired on 29 November. Come to the impugned order. Come to the impugned order. Second paragraph, petitioner contended in his writ petition that his father was an employee of CSTC and expired on 29 November 2007. Meaning thereby, today we are in 2025, then 13 plus 5, 18 years back. So 32 minus 18?
32 minus 18, my lord, 28. That was considered.
32, 22, 8, 15 years. You are not major. You have no right to be considered for appointment on compassionate ground.
That was considered, my lord.
Show me the provision, I am ready to accept it. If the provision, if it is provided in the scheme, otherwise not. Yes, Mr. Mr. Biani, whether is there any scheme?
Just 2 minutes. Firstly, my lord, kindly, I'll just take 2 minutes. I know lordship is before vacation hard place. Kindly takes only one paragraph. I shall not place the impugned order, which I have handed over to your lordship, my lord.
Yes.
The impugned order, my lord, which I have handed over to your lordship. My lord, kindly take the second paragraph, which just filled from your lord. The second paragraph, the first page, second paragraph. The petitioner contended in his writ application that his father.
Sentence stands undoubtedly.
No, the petitioner contended. First page, second paragraph.
Oh, first page.
Lordship. The petitioner contended in his writ application that his father was an employee of CSTC and expired on 29/2007. At the time of the death of his father, he was a minor. Therefore, his mother, such and such, applied for appointment compassionate ground. He alleged that he made several correspondences, but he was not offered any employment of the compassionate. But there is nothing to show as to when and how the writ petitioner submitted his application.
That I have seen.
Now, but bereft of this. Number one, no, there is no scheme in CSTC. There may have been a scheme in CTC, not in CSTC. Now, where
Upendra Ray's case was considered.
I'll come to Upendra Ray's case. Well, Upendra Ray was CTC, not CSTC.
Yes.
Now,
in CSTC, there is no scheme.
That is recorded in the order also. I'll show you.
Yes, that is the purpose.
Now, he has referred to 2 pages. Kindly takes page 19. Oh, that I'll tell you, lordship. 19 is of 2011. Page 19 is of 2011. 19 is to 2011. I will not place it. Just the date. It is 2011. Well, kindly do not go through it. I take his words that whatever he says is correct. 19 is of 2011. And page 31 he has relied upon is also of 2011. Now, my lord, the position is this. If your lordship goes to the impugned order, your lordship will find. Just kindly takes second page of the impugned order. My lord, the third paragraph, it starts with now undoubtedly, which is lordship was saying. Undoubtedly, the objective of granting compassionate appointment, my lord, kindly goes, provided there is a scheme for such employment on compassionate ground. In fact, then kindly says, in fact, the Labour Department, by notification of 3rd September 2013, withdrew and or superseded its all previous orders and notifications regulating the appointment on compassionate ground, thereby restricted the scope of such scheme for a compassionate appointment. Number one, 2011 goes. Number two, as early as in this 24th January 2025, when I'm handing over to your lordship, the state government writes to the secretary to the Minister of Transport Department, saying that there is no scheme. If there is any other order after this 2013 Labour Department, everything goes. Not only in CSTC, in everywhere, everything goes. So now, what? Refuted recording. এক সেকেন্ড দিয়ে দিচ্ছি তোকে। দাঁড়া একটু দিচ্ছি, ওন করছিস কেন? পড়িনি পড় না বলছি। পাঠ করিস না, এটাই তোকে আমি জেরক্স করে দিতে। কদিকে দেবো না দিয়ে দাও। আরে ভালো ওকে বলতে হবে।
Yes.
Number one thing, only as per apropos this, kindly see paragraph 4 of that order. As of now, there is nothing. As of after 2013, there is nothing. Even prior to 2013, that was a different question. After 2013 Labour Department's notification.
Yes, as it is referred to 251 EMP dated 3rd September.
I'm deeply obliged. That is reflected
in all other schemes.
That is reflected in the impugned order also. So after 2013, there is no scheme, and CSTC does not have a scheme.
And the case of Upendra is in case of CTC.
So far, this continuation is there. My answer is there in page 31.
And moreover, a minor has no right at all.
31 is of 2011.
I have to convince you.
Yes,
Lordship, on
31
that
is of
point.
You will
2011.
convince me.
I'll have to convince.
Yes.
Otherwise, I am out of the court. my
Yes,
lord.
31 is of
Page 31,
2011.
Paragraph 1. STU means the state transport undertaking of the government of West Bengal. State policy is applicable to the STUs under transport department, namely North Bengal State Transport Corporation, Calcutta State Transport Corporation, Calcutta Tramways Company CTC, and West Bengal Surface Transport Corporation. So, Lordship, this distinction is not standing in the eye of law. So the same policy is followed everywhere. The state cannot follow one policy in terms of one transport corporation and other in terms of other. The scheme is same.
Well, the admin is in. I'm sorry.
Yes, go on arguing. I am hearing.
My lord, if your lordship takes in another way, lordship is asking me to argue on Mr. Chatterjee.
Both will argue side by side. Yes. Yes, Mr. Chatterjee.
My lord,
and Lordship, kindly now let me read Upendra, and then your Lordship consider this Upendra whether it is applicable in my case.
judgment করছে the place করলি বললাম এফিডেভিট করবো এফিডেভিট বুঝতে বল না কিংবা whatever Mr. Gani is saying, let him come on affidavit. But opposition বলিস না ফালতু করছিস কি করছে sorry. দুটো শ্যান্নাল আর তোমার সেন বলে একটা মেয়ে আছে গুড টিম অরিন্দম ব্যানার্জি আমার টিম দুটো মেয়ে চেয়েছিলাম আমরা সুতো পাওয়ার জন্য দুজনেই বা প্রতীকদা তোর আর দিয়ে তার নামটা আমাকে আর জয়ন্ত এই চারটে নাম আমাকে ও তো বদমাস ওটা জয়ন্ত তো আমার ব্যাস না
Yes, yes.
May I please Upendra's judgment once?
Upendra's judgment.
Because of similar situation, also I said.
How it can be similar situation because two organizations are different. Even if Upendra's judgment, there is a direction for appointment, but it is a case of right of a minor to be considered for appointment on compassionate ground if the petitioner was minor on the date of death as it is recorded in the impugned order, you have no right unless scheme does not provide.
That is no, has coming from your lordship's mouth today. Lordship, that question I will have to answer.
Yes.
It is coming from your lordship.
No, it's not. It's a settled position.
Yes, my lord. That
It is a settled position.
is not taken by them.
Yes.
Coming from the bench, my lord.
It's
It's
in the
not a
order.
part of the impugned order.
It's in the part of the impugned order.
But impugned order doesn't say that it was minor and.
বলেছে, এই তো first পাতা।
That said, where there is no documents. There is a different, my lord, in my reading, subject to correction.
Yes.
I say, my lord, state cannot say that they can be discriminated on the basis of the different organization. That is controverted by paragraph.
Whether Upendra was minor on the date of death.
That answer I will give. Lordship, STUs are STUs. They cannot distinguish between CTC and CSTC.
Yes.
As per section paragraph 1 of page 31. Lordship, kindly come. STU means what is state transport unit, state transport undertaking of the government of West Bengal. So all the state transport undertakings of the government of West Bengal were guided by the same notifications in respect of the compassionate appointment. Now your lordship wanted me to address your lordship on the question that whether the minor, there was a provisions under this scheme for minor can apply or not. Now, lordship, kindly come.
Yes.
For the purpose of the appointment of the financial compassion appointment ground, the dependent of an employee shall be mean wife, husband, unmarried daughter, employee who was solely dependent on the employees. One of the dependent of the employee who died in harness, who retires permanently on being declared incapacitated. Now, lordship, kindly come here also. Lordship, so far this policy says there is no express function. I say, Lordship, if your Lordship grant me time, I can come.
No, there is no question of granting time. It is settled position. Division bench judgment. I was author of a division author of one judgment. Azim Gaji. I was part of that division bench. After that, it is settled.
But in case of Upendra, Lordship, kindly consider the Upendra judgment.
How Upendra will be considered? If it was not a case of minors' right. It is not a case of minors' right. Upendra will not come in the way.
Kindly come.
I will not consider. If you can demonstrate that in Upendra's case, minors' right was considered, then I will consider it.
May I go through this Upendra's petition and come back?
Yes, sure.
That I have.
In the writ petition, order of Managing Director, Calcutta State Transport Corporation, dated 4th August 2025. 4th August 2025 is questioned as now whereby prayer of the petitioner for appointment on compassionate ground was panned. Stop. Father of the petitioner was an employee of Kolkata State Transport Corporation within bracket for short CSTC close bracket, and who died in harness on 29 November 2007. Stop. At the time of death of father, petitioner was minor. Stop. After death of father, petitioner's mother applied for appointment on compassionate ground. Stop. Previously, a writ petition was filed being WPO 1336 of 2023 within bracket Joy Das versus the state of West Bengal and others, claiming appointment on compassionate ground, wherein a coordinate bench video order dated 22nd May 2025 disposed of the writ petition, thereby directing the concerned authority of CSTC to take decision in accordance with it, relating to claim of the petitioner seeking appointment on compassionate ground. Stop. However, in the said order dated 2nd May 2025, all issues were kept open, and there was a direction.
I'm sorry to interfere, madam, but kindly see
that the order passed on 27th April 2022 in the writ petition being WPO 1240 of 2021 within bracket Upendra Kumar versus State of West Bengal and others, requires consideration by the concerned authority of CSTC while deciding the claim of the petitioner for appointment on compassionate ground. Stop. Next paragraph. It is submitted by Mr. Chatterjee, learned advocate representing the petitioner, that while deciding the claim of the petitioner seeking appointment on compassionate ground, video impugned order dated 4th August 2025, order of the coordinate bench in Upendra Rai Supra, Upendra Kumar Supra was not considered, and due consideration of the ratio of Upendra Kumar Supra would have changed would have altered the situation, and claim of the petitioner would have been decided otherwise. Next paragraph, Mr. N.C. Bihani, learned senior advocate representing CSTC, has opposed this writ petition based on the decision taken by the managing director CSTC dated 4th August 2025. Stop. It is submitted all previous orders and or directions relating to appointment on compassionate ground were either withdrawn or superseded. Vide notification number 251-EMP capital dated 3rd September 2013, issued on behalf of the Labour Department, Government of West Bengal. Stop. Relating to claim of the petitioner for appointment on compassionate ground based on ratio of Upendra Kumar Supra, it is submitted that it was a case under CTC. It was a case under CTC, full form Calcutta Tram Company.
Tramways Corporation.
Calcutta?
Tramways Corporation.
I will just check now.
Company na corporation, Baba.
Calcutta Tramways Company and
Company.
It was a case of Calcutta Tramways Company.
Limited.
And in the present case, petitioner is seeking appointment under CSTC. Moreover, it is asserted that there is no scheme prevalent which confers right upon dependent family member of the deceased employee to get appointment on compassionate ground. Next paragraph. On submissions being made on behalf of the parties and taking note of the relevant materials available on record, it is found that nothing is demonstrated demonstrated which shows existence of a scheme relating to compassionate appointment as on date, which could have been pressed into service in order to decide the claim of the petitioner. Stop. Moreover, on perusal of the impugned order dated 4th August 2025, it transpires that all previous orders and or notifications regarding appointment on compassionate ground were either withdrawn or suspended. Vide government notification number 251-EMP dated 3rd September 2013. Stop. Next paragraph. In absence of valid scheme, right of a dependent member of a family of right of dependent family member of deceased employee who died in harness cannot be taken into consideration. Stop. Next paragraph. Moreover, what is striking, that petitioner was indisputably minor on the date of the employee on 29th November 2007. As it it appears from the affidavit in connection with the present writ petition that present age of the petitioner is 32 years. Therefore, on the date of the employee on 29th November 2007, he was minor. Stop. In the case relating to appointment on compassionate ground, unless scheme provides a minor at the time of date of employee has no right to be considered for appointment on compassionate ground. Stop. In this regard, reliance is placed on so and so. Stop. Next paragraph. In view of aforesaid situation, no relief can be granted to the petitioner. Stop. Writ petition stands dismissed. Urgent xerox certificate.
Well, only one thing, since I've handed over the impugned order today, the full order in court, Lord, kindly keeps it on record.
আচ্ছা, ওখানে যে মিস্টার বিহানির যে সাবমিশনটা ওইখানে একটা লাস্টে বলে দাও, ফুল কপি অফ দ্য অর্ডার ডেটেড 4th August 2025 passed by the managing director CSTC is filed today and semi-statement.
I'm deeply obliged.
It is Anirban Choudhury and another 2 matters of WPST was decided by Justice Dotto sitting with Justice Vivek Choudhury. Anirban Orindam.
There are 2 persons.
Anirban Orindam. It was decided there. It was the eligibility were laid down in vividly, and where it is specifically held that in absence of a provision in a scheme, minor has no right. Relying upon Orindam Onirwan, I delivered a judgment sitting with Justice Dotto. I authored a judgment. That was a case of Azim Ghazi versus State of West Bengal and others. And the recent judgment of Justice Dotto in Supreme Court. Ajit Kumar GK.
Yes.
Nothing remains. If you are a minor, yes, it can be considered if scheme provides. Otherwise, not. If scheme is silent on this issue, you have no right.
Item number 7. Petitioning this matter, my lord. Here, my lord, up to 35 years. Up to 35 years, the petitioner is entitled for employment. Up to 35 years of age, the petitioner is entitled for employment. Now, my lord.
Compassionate ground?
Yes, my lord.
Conversion.
Now,
you are confident to get the matter heard now after previous matter. It is factually it is different. Very well.
It is covered by your lordship's order. It is covered by your lordship. No, earlier order is there.
Earlier what order, my lord?
Earlier order is there.
No one appeared. That's why no hearing.
After twice, my lord.
What he said.
My learned friend, my lord.
What my learned friend?
Wake up, my lord. Matter was taken up twice.
Kindly take up.
Matter was taken up twice.
December 20.
Your lordship has already passed the order in original side. So, in a second time, my lord, your lordship. Usually, my lord, is second time, my lord.
You should have brought it to the notice of this court. How this is maintainable in the original side?
But second time, your lordship already passed the order, my lord.
A conversion order আছে না original side এর যে কোনো থেকে appellate side এ অনেকগুলো দিয়েছি তুমি নিয়েছো mention before the appellate side দেখবে তুমি আগের দিন
I am for the petition in this matter, my lord.
Item number 8, I have been instructed to appear on behalf of the Bharat Coing Co. Limited today morning over telephone, my lord. My client also informed me no copy of the writ petition is available with him.
No, affidavit of service is there. If they, my lord, loses the copy, what can be done?
Coal India Limited is maintainable.
Coal India Limited also appearing, but they are also not found any copy of the writ petition.
Let them take instruction, my lord.
What is the matter about?
Matter is, my lord, there was an accident way back in 1993. There was a disciplinary proceedings initiated against me, and subsequently, my lord, inquiry report. Accident. Some people have died.
Course of duty.
Yes, some people have died. In the underground, there is a, my lord, broken off, my lord, the wall, and water has, my lord, put into the, my lord, mines. And I was, my lord, charged on that, my lord, particular colliery, though I was not shifted on the particular time. Subsequently, my lord, inquiry was held. Inquiry officer opined that I am not guilty of the charges. Now, thereafter, my lord, the several representation has been made to them for giving me the all benefits at par with the other persons, those who have involved with me in the same incident. They have given the benefits to the similarly situated persons except the petitioner, my lord.
Benefit
of promotion, increment, etc. Whatever, my lord, attached with the service. But I am in a same position as was during that time.
Your similarly circumstanced other employees are getting benefits.
Yes.
Why those benefits are denied to you?
Nothing has been disclosed, my lord, as to why they have not. Because
a prayer made.
My lord, prayer made, my lord, if your lordships kindly come. Promotion in accordance with his seniority with all consequential benefits. And I am going to return 31st May 2026. Inquiry report to query. Inquiry report. But if your lordships kindly come.
You have retired in the meantime.
No, I will be retiring in May 2026. If your lordships kindly come, page.
You'll take instruction, come.
P6, my lord.
Only submission, my lord.
So why petitioner is being denied
I
the
don't
benefit
know.
of promotion? Take instruction. come.
Instruction, my lord.
There's no use
One-
of hearing.
one submission, my lord. My learned friend sent to me the cause title of the writ petition, where I found that item number, response number 1, Coal India Limited, address 10 Netai Subhash Road. But there is no office of the Coal India Limited, my lord. That is the Rajarhat is the office of the Coal India Limited. No, there is no office. I have today, my lord.
Still in Coal India matters, I am entertaining
Yes.
because they have at least an office at Kolkata.
Yes.
It should be converted in an appellate side.
Obtain instruction. Don't take this point in an appropriate case. Take instruction, come back. Matter is taken up for consideration when learned advocate representing Coal India Limited has prayed for accommodation to
Coal India and Bharat Coking Coal Limited.
learned advocate representing, you are representing both. The learned advocate representing Coal India Limited and Bharat Coking Coal Limited has prayed for accommodation to obtain instructions. Stop. Next paragraph. Hearing of this matter stands adjourned. Next paragraph. List the matter under the same heading in the monthly combined list of January 2026.
Copy of the writ petition.
Yes, on payment of costs. Pay cost.
Number 9.
If my lord may kindly produce the last order passed by your lordship on 3rd of December. The Provident Fund dues has not been released. I am an employee. There was a disciplinary proceedings. After my superannuation, my service rule does not permit for continuance of the disciplinary proceedings after superannuation. On that basis, my letter was issued dropping the charge sheet. So after the dropping of the charge sheet, they are required to release my retirement benefits. Only what they have released is the gratuity and leave encashment to some extent. But the Provident Fund has not been released, and the leave salary for the period under suspension, that has also not been paid. Because final payment bill has not been issued to me, so I cannot ascertain the exact amount. And I have prayed to that extent that Provident Fund may be released.
When you have retired?
My lord, may kindly see the last order.
Last order?
Yes, passed by your lordship.
Just a minute. Just a minute. Strike. Yes. Now nothing is paid after your superannuation.
And
Not your
only-
superannuation. A proceeding was continuing against you by keeping the petitioner under suspension. Or
Yes, yes, yes. Suspension,
that suspension period, petitioner retired.
retired, and there is no provision on under my service rules for continuance of the disciplinary proceedings after superannuation. On that basis, my
Now, what is your instruction? Whether the proceeding has been abandoned?
My lordship, we have forwarded the claim to the state on 5th June 2025. So we are waiting for the fund so that we can proceed with the
on the
payment.
last occasion, your lordship was pleased to record.
Just a minute. 5th June 2025.
Yes, my lordship.
Now, thereafter, no response.
No, we don't receive any.
Only a part of the
Now,
gratuity.
what are the dues which are required to be released in favor of the petitioner?
My lordship, we have already paid for 3,54,000
Towards
towards the. My lordship, 1 minute. On the head of leave encashment. On the head of leave encashment. Yes, my lordship.
And what about provident fund and gratuity?
My lordship, for that we have already raised the claim to the state
Who
and
is appearing for the state?
My lord, I am appearing on behalf of a state, my lord.
Yes.
My lord, the concerned authority is not part in this writ application. My lord, please give a direction to the corporate transport corporation to provide me a copy which they have sent to the concerned authority, my lord. Thereafter, within 4 weeks, I will release the same.
State of West Bengal represents Secretary Transport Department is party.
My lord, that's why I have no documents what they have claimed, my lord. That's why I am praying before your lordship. Direct them to serve me a copy of the requisition and you may record it on record, my lord. Within 4 weeks, it will be released.
It is submitted that on 5th June 2025, claim was forwarded to the corporation, to the state authority.
My lord, but I have no information where the document,
Where is the
to
claim?
whom they have sent the document.
Show me the claim.
my lordship, I have it in soft copy. So if you allow
I
me,
know, I have directed you to obtain instruction. So it is your duty to
I
place
apologize,
on
my
record
lordship.
the hard copy of the claim.
I just received
Man
it
who
few
is
minutes
retired
back, my
long
lordship.
back and is not getting benefits.
Yes, my lordship, I
Yes.
understand.
Why you have not brought?
My lordship, please give me
3rd December 2025, directing both the state as well as the corporation to obtain instruction, and you are not without the copy of the claim.
my lordship, we have received it just few minutes back. So please allow me to come with the document, my lordship.
When you will come?
My lordship, tomorrow.
Only 4-5 days are left, and next Wednesday will be the closing date.
My lordship, tomorrow.
Tomorrow is not the original site date. It will not be taken up according to your
Yes, my
sweet will,
lord.
madam.
Yes, my lordship.
This matter was taken up on 3rd December 2025.
My lordship, please allow me for short passover so that I can come back with the printer.
We will come back.
I'm
10 minutes, come back.
I'm grateful,
Get a
my lord.
printout,
I'm
take a
grateful.
printout and come back.
I'm grateful.
Passover. Passover.
My lord. Number 10.
Lord, this is my application.
My lord, I was, my lord, selected as a clerical cadre in the State Bank of India, my lord. This was in 2012. My lord, I was appointed in 2013, 7th of January. My lord, for probation in
7th of January
2013. My lord, I was confirmed after completion of the probation period on, my lord, 16th of September 2013. Thereafter, my lord, I continued with my service. In the meantime,
as probationary,
my lord, as an assistant.
2013.
2013. My lord, my wife committed suicide on 8th of January 2014. And my lord, pursuant to the complaint lodged by my father-in-law, an FIR was initiated under 498, initially under 304B. My lord, the trial continued and my service also continued. In the meantime, my lord, I was promoted to the post of G. My lord, JMGS with effect from 1st of May 2018. In 2018, I got that. JMGS, my lord, Junior Management Grade Service 1. This was, my lord, on 1st of May 2018. My lord, the learned trial court convicted me on 29th of July 2025. Me, my father and my mother. 3 of them. My lord, against that order of conviction, I preferred an appeal. My lord, His Lordship Justice Shubhra Ghosh, my lord, suspended the sentence. This was on, my lord, 24th of September 2025.
24th September
2025.
22.
25. This year, my lord.
Yes.
My lord, I was discharged from service on 16th of October 2025. On the ground that, my lord, I have been convicted. My lord, immediately thereafter, on 22nd of October 2025, I prayed for reconsideration of that discharge.
22nd October
22nd October 2025, highlighting that, my lord, the conviction has been suspended by this honorable court.
But conviction remains. You have not been acquitted.
Not been acquitted.
It's a suspension of
Suspension of sentence.
So why you will be
relying upon this judgment? This judgment. Yeah, absolutely. Ram Gopal Sikdar.
Their conviction was
stayed, not suspended.
Not suspended. My lord, that is the only difference. Lordship kindly comes to page 106.
Any other judgment?
My lord, this is the only 106, my lord. The honorable court, my lord, observed that there is remote chance of the appeal being heard in near future. In view of the above, this court is inclined to suspend the sentence of the appeal. My lord, my humble submission is, my lord, in view of suspension of the sentence, my lord, pending hearing of the appeal.
There is a judgment of Justice Bhaskar Bhattacharya that even if the order is stayed, the order against which appeal is preferred, that order does not obliterate.
But I stand corrected. My lord, only in this view of the fact, my lord, I have preferred this. If your lordship may kindly consider.
Where is the order of conviction?
Conviction order is, my lord, page 106, my lord, page 38.
Page 38?
38, my lord. The final order and it follows the judgment and order.
Page 38.
38 is the order, my lord, and the sentence your lordship will find at the after the judgment at sentence starts from, my lord, page 100.
This is order dated, order of conviction is dated 29 July
29th of July 2025. And the sentence, my lord, starts from page
29 July 25, page 39.
39. It's the order. And the sentence, my lord, we'll find at page 100 onwards.
Page 100.
100.
And what is the order of the appellate court?
My lord, at page 106.
Tell me,
my lord,
if appeal is heard after 5 years,
my lord,
and there is no interference of conviction order,
my lord,
then what will happen?
my lord, if the conviction order is
Then the conviction order which is passed by the trial court would be finalized.
my lord,
So why petitioner will be permitted to work at this stage?
my lord, this is one aspect of the matter. On the other hand, my lord, if I get acquitted, my lord, then, my lord, getting back to the work after 5 years, my lord,
Yes,
will be a difficult
yes.
task.
You will be permitted to work, and your prayer for back wages can be considered at that point
My
of
lord,
time.
this is one aspect of the matter. And the other aspect, my lord, moral turpitude, as has been, my lord, interpreted by the Honorable Supreme Court. Because initially it was, my lord, 498A and 304B. And, my lord, convicted under section 306, that is, my lord, abatement of law.
Affidavit service to audience at 30. Matter is heard in presence of the learned advocates representing the petitioner, and State Bank of India being the contesting respondent. Stop. Next paragraph. Petitioner was an employee of State Bank of India. Which branch?
My lord, commercial branch, Kolkata.
Torkani branch, State Bank of India, who was implicated in a criminal proceeding which culminated into an order of conviction dated 29 July 2025. Passed by Additional Sessions Judge, First Court, Barashat. Stop. Petitioner along with two other persons were found guilty for commission of offense under section 498A/306/34 of the Indian Penal Code. Stop. It is submitted by the learned advocate representing the petitioner that criminal proceeding initiated due to unnatural death of petitioner's wife. Stop. Next paragraph. Petitioner preferred appeal against the order of conviction before the High Court. Being CRA within bracket SB close bracket 111 of 2025, in connection with which an application being CRAN 1 of 2025 was moved by before a coordinate bench. Stop. In the application, stop. From next paragraph, from the order passed by the coordinate bench on 24th September 2025 on the aforesaid appeal and application, it appears that the petitioner being one of the that the petitioner herein being one of the appellants sought for suspension of sentence. Stop. However, coordinate bench video order dated 24th September 2025 granted bail on certain conditions, including appearance of the petitioner before the learned magistrate once in a month till disposal of the appeal. Stop. Next paragraph. Prayer is made by presenting this writ petition, which would permit the petitioner to resume his duty as an employee of State Bank of India, subject to final result of the appeal. So in support of such submission, reliance is placed on an order passed by a coordinate bench dated 12th September 2013 in a writ petition being WPA 16734 of 2010 within bracket Ramgopal Shikdar versus the State Bank of India and others. Next paragraph. However, it is rightly pointed out by the learned advocate representing State Bank of India that in Ramgopal Shikdar Supra, order of conviction was stayed in appeal. But in the present case, prayer was made for suspension of sentence, and the coordinate bench, video order dated 24th September 2025, granted bail. Stop. Appeal is still pending for final adjudication. Stop. Next paragraph. This court cannot shut its eyes to the fact that petitioner was convicted of offense under section, convicted of committing offense which is punishable under section 498A/306/34 of IPC, and the trial court video order dated 29 July 2025 sentenced the petitioner thereby directing that the petitioner shall suffer rigorous imprisonment of 7 years and payment of fine of rupees 50,000. With default clause. Next paragraph. Considering the aforesaid facts, court is not inclined to permit the petitioner to resume duty at this stage when appeal is pending. Next paragraph. A writ petition stands dismissed. Arjun Jalak certificate, please. For
First matter, item number 2.
Item number 2, Your Lordship, Mr. Parthok is appearing, Your Lordship.
Well, if your lordships kindly see the order passed by the coordinated bench on the earlier occasion, my lord, I have, my lord, cited one judgment covering the issue, and my learned friend is to answer that, my lord, part. If your lordships kindly see the order passed by my lord Justice Aniruddha Rai.
Mr. Ghosh convert this writ petition.
But this has
I had also made the same thing that it should be converted.
Well, it has been
And
entertained, my lord.
CL doesn't have any office in RN Road.
Well, it has been entertained earlier, my lord.
No one appears for the petition.
No, before that,
no one appears on behalf of the respondents and no accommodation.
Before that, my lord, kindly see the order passed by my lord Justice Aniruddha Rai. Kindly see, my lord. I have concluded my argument.
It is not a case where your argument was concluded.
But
nothing is recorded to such a to that extent.
But my lord, I have, my lord, made extensive submission. My learned friend, my lord, was there, and my lord.
That is not reflected from the order dated.
But today, my lord, he has to answer, my lord, that the judgment which I have cited on covering the issue, though it is not recorded, but ultimately that has possibly recorded that my learned friend will answer whether the division bench is applicable in this case or not. A law laid down by the honorable division bench that has been recorded. Kindly see.
None of the respondents are within the original side jurisdiction.
Entertain, my lord. Otherwise, in the initial stage, I would not have, my lord.
No effective order was passed. Only a mere adjournment by 3 or 4 lines order.
My lord, they have not objected on
in some of the matters. I have entertained.
Yes. I know, my lord.
Where there is a specific, there are certain.
Yes. I understand, but my learned friend
fully well that it is not maintainable.
Yes.
Since coordinate bench entertained the position on the original side,
my lord.
I allowed your prayer,
my lord.
And I entertained, but this is not the.
But my
not the matter under such category.
My learned friend has not
conversion. There was similar order আগে নিয়েছে অনেকগুলো তুমি আগে যিনি ছিলেন ওটা থেকে নিয়ে নেবে.
Number 3.
Coal India, even Coal India, I am entertaining.
My lord, in
so it is in New Town, I am entertaining.
My lord, this matter, my lord, earlier order was passed. If your lordships kindly see, my lord, the lordships order and the earlier order passed by this honorable court.
My lord, this case also may be converted to appellate side.
No.
The
if your lordships kindly
MPL
see, my
has
lord,
no office at R.N. Mukherjee Road, 13 R.N. Mukherjee.
18 September 2025 order, kindly see.
They have intentionally mentioned to get the jurisdiction of the original site.
They never objected. Today, my lord, since your lordship's view, my lord, they have, my lord, seen and now they are objecting.
In previous occasion, my lord,
they could have objected.
This view is prevalent right from Justice Satyabrat Sinha.
Yes, my lord.
As his lordship then was.
Yes.
This is not my view only.
Yes. No, but earlier bench, my lord, they could have objected. They have not objected, my lord.
We have objected.
I'll see their submission, how they have objected.
It is nothing, only to get the matter hard early.
Well, kindly see Mr. Shah has...
Considering the length of list on the in the appellate side.
Well, kindly see Mr. Shah has, Ms. Shah has placed a communication and submit that the Coal India Coal Company has already communicated the petitioner as to the requirement of certain further documents, but till date no response has been received.
Just a minute. Yes, I am on this,
my lord.
On this order. Just a minute. Yes, there is an order to that extent because submissions were made, communication was issued to the petitioner for submission of certain documents, and there was no response from the petitioner. That's why court passed an order. I will entertain.
My lord, only it is my duty to bring under the notice of the honorable court why they have intentionally wrongly mentioned the address. That address is not correct address. That office has been withdrawn long ago.
In an appropriate case, when the first instance court will hear this matter, court is converting those petition into an original side, from original side to appellate side. But since the coordinate bench has heard this matter to certain length, so therefore the court is not inclined to pass an order for conversion. Yes.
Now here, my father of the petitioner was an employee, and he was undergone treatment and subsequently he was found unfit for duty, and my lord, his father was, my lord, terminated from the services on the medical ground. Now subsequently I have made applications, and my lord, they have, my lord, screened the petitioner, medical was conducted, and everything, my lord, has already been completed. Now after that, my lord, if your lordship kindly see page, my lord, 36, my name has also been placed. Kindly see the heading, status of employment under National Coal Wage Agreement up to January 2023.
Page 33.
Page 36, my lord.
36.
My lord. The starting page. At top, you will also will find the pending matters, and on right hand side, approved matters at top. And thereafter, you will also kindly see status of employment under National Coal Wage Agreement.
Employment on compassionate ground.
Yes.
When employee died.
No, it's a medical unfitness case, my lord.
Declared medically incapacitated.
Incapacitated in 2015.
You have made an application when?
Immediately. Immediately.
Now, what is the present status?
Present status, my lord, kindly see. They have displayed page 39, WD 6195.
Page 69.
39.
Yes, page 39.
39, you'll also find WD 6195.
6195.
6195. Timothy Dhani Sethi. Sorry, my mother was incapacitated, not father. Sorry.
Mother?
Mother was incapacitated. Mother was an employee.
Mother was employee.
Yes, I have said father, not father. Then you'll also will find my name Shiva Sethi, son processed. So since 2015, my name is under consideration. Till date, they have not provided interest.
This process was made when?
Process was made since 2015.
My lord, we have made a communication to the petitioner in 2018. That is not on the record, but this communication was handed over to the learned advocate by the order dated 18 September 2025, that till that date, no document was submitted as required by the, let me finish.
What are the documents?
Now the things, as on date, till that date, no documents was submitted. In the meantime, regulation has been changed, policy has been changed, and under new policy, a bi-party committee for coal industry has been set up to review and to give implementation instruction. I'm giving the clause number
9.4.0.
9.4.0. On clause number 9.40, a subcommittee shall be constituted which shall submit its report to the standardization committee of JB, joint JB CCI 11, joint bipartite committee for coal industry, till this status quo shall be maintained.
When this
my lord, till that time, this case.
When this scheme was introduced.
My lord.
When this scheme was introduced, new scheme.
2023.
But the husband, mother was declared physically incapacitated in 2016. Application was made in 2016. You made the delay in processing, for which you will get leverage.
Unless the employment is completed, till that time, the new policy
No,
will come.
already you have stated
My lord,
that it is processed.
My lord, kindly, I may be allowed to submit. In the similar situation, coordinate bench has given a order in another case, only directing the respondents to pass a reasoned order. Like that, I am not telling that I may be given to file chance to file report. We may be given to pass a reasoned order stating all the material facts in respect of their representation. Under the same reasons.
Last minute.
কপি দিন আমাকে দেখুন দেখুন আপনার কপি দেখে দিচ্ছি
দিয়ে দিচ্ছি কপি
He is making submission that the matter may be relegated to the authority for taking decision in the first instance.
So they have processed.
Because unless and until it is formally decided regarding your entitlement, court should not embark upon whether you are eligible to get the employment on compulsion ground or not.
Only one thing may kindly be recorded. Is the petition found to be eligible, or let the process?
Consequential steps shall be taken. Who is the authority to take such decision?
Only one thing may kindly be recorded. That it is a
Page 39. It was processed.
It's processed, and they have mentioned in this order the National Collegiate Agreement 11. My case is covered in 9. That may kindly be recorded.
Yes.
In this case, for the matter of HCW 9, 11, my case is 9. You also will find from page 26 of the writ application.
Page 26.
Well, as per clause number 9.440 of NCW 9. I have been declared, my mother has been declared medically unfit under clause number 9.4.0 of NCW 9. That may kindly be reported. So, yeah.
No, it is National Coal Wages Agreement 9. No, 11. 11.
11 in this matter, the order which has been cited. But my case is covered under National Coal Wages Agreement 9.
No, in that regard, authority has to take decision. Because if you go by the Supreme Court judgments, there are judgments two ways.
Don't mention any NCW.
Yes. That is the main issue. Whether the scheme which is prevalent at a time of death will apply or at the time of consideration. Latest judgment, last judgment of the Supreme Court headed by Justice D.C. Raj
But T10 scheme is there. My landed fund has cited the.
So instead of going into this aspect, let it be decided.
Don't mention any NCW, kindly mention only NCW.
Issue. In 2016, he was declared medically unfit. 15. Where is the order relating to or the report of the medical board?
Medical board report, they included you will find, my lord, page 27. Dhani City, General Mazdoor, Southern areas are hereby terminated from services with effect from 14th October 2025 under voluntary retirement on medical.
Matter is heard in presence of the learned advocates representing the petitioner and Eastern Coalfields Limited, within bracket for short ECL, close bracket. Next bracket. Mother of the petitioner was employee under ECL. Who was declared medically unfit. And was permitted to retire voluntarily on 14th October 2015. Stop. In this regard, an office order was issued by the concerned authority of ECL on 13/14th October 2020. Stop. Page 27, what is the date? 14th October 2015. 2015, 2029, 2015, stop. Petitioner, being the son of the aforesaid employee of ECL, by presenting this writ petition has claimed direction or has prayed for direction upon the concerned authority of ECL for providing appointment on compassionate ground. Stop. Next paragraph. It is brought to the notice of this court in reference to a document at page 39 of the writ petition that application of the petitioner for appointment on compassionate ground was duly processed by the concerned authority, and it is alleged that thereafter no steps were taken to appoint the petitioner on compassionate ground. Next paragraph. Learned advocate representing ECL submits that there is introduction of new scheme requiring compliance of formalities under the said scheme relating to appointment on compassionate ground for which would make the petitioner eligible to be appointed accordingly. Next paragraph. Though application was made long back, just after permitting the petitioner to retire voluntarily, since petitioner was declared medically incapacitated, but till date no decision is taken by the concerned authority of ECL on the claim of the petitioner seeking appointment on compassionate ground. Next paragraph. Next, this court finds, this court finds, no purpose would be subserved in keeping this writ petition pending. Stop. Who will decide?
Respondent number 7, the agent.
No.
Director Personal is the highest authority.
Director personnel ECL. Director personnel within bracket ECL, being respondent number 3, is directed to decide the claim of the petitioner seeking appointment on compassionate ground by 8 weeks from the date of communication of this order, and said respondent number 3 shall pass a reasoned order after granting opportunity of hearing to the petitioner or his representative. Stop. The decision to be taken by the respondent number 3 shall be communicated to the petitioner by fortnight thereafter. Next paragraph. If respondent number 3 decides that petitioner is eligible to be appointed on compassionate ground, consequential steps shall be taken to complete the formalities prior to appointment of the petitioner. Disposal bole sir, writ petition is disposed of. Writ petition is disposed of. Urgent xerox certificate.
My lord, instead of deciding the issue by the director personnel, any other officer authorized by
He is the appropriate authority. Sorry.
Item number 4.
May I file my exception?
Your Lordship, there was a direction for me to file affidavit. The affidavit was made ready and the same was served upon them, but inadvertently the entire original file from the court has been misplaced, Your Lordship. So I need to reaffirm the affidavit, Your Lordship.
Previously, affidavit was affirmed and filed.
It was affirmed. My learned senior was served with the affidavit.
So the question of reaffirmation does not.
Your Lordship, but the original file is.
It was not filed in the department.
No, it was
file
not.
an affidavit.
Your Lordship.
Yes.
The exception can be only taken once my affidavit comes on record, Your Lordship.
Oh, that affidavit copy is with.
Your Lordship, the original.
File it. Yes. Exception is filed on behalf of the petitioner and same is taken on record. Next paragraph. Ms. Pandey, learned advocate representing ECL.
Your Lordship, all the respondents
has submitted that a reply which was affirmed on behalf of ECL is lost, and prayer is made to grant leave for reaffirming the affidavit prior to filing of reply. Stop. Next paragraph. Leave is granted to the leave is granted for reaffirming the affidavit in connection with reply by 24th of 24th December 2025, and same shall be filed by 7 days after the ensuing Christmas vacation. Stop. List the matter under the heading hearing in the monthly combined list of list the matter under the same heading for further consideration. On 21st January 2026.
Your Lordship, there are no admitted dues. Sincerely obliged.
Item number 5.
My lord, in similar situation, this case,
Something different if it is cancelled also last autumn.
I have got the written instruction. The instruction to the
Yes, my lord, they submitted on the last day. My lord, that petitioner has crossed the age limit of 35 years. No, they have submitted, there is a discrepancy between the two documents, that is service record as well as the matriculation certificate. That's why they cannot process the employment. The lordships observe, my lord, kindly see that if there is any dispute between the two records, then the matriculation certificate will prevail. Now, if your lordships kindly consider that even in a matriculation certificate, yes, my lord.
দিতে হবে না এটা আমরা প্লেস করছি it is the instruction for same reasons it is My lord, in this case, though we submitted on the last occasion that there is contradiction about age, and your lordship my lord, at present, that we will solve regarding age, but constraints is coming only for that bi-party committee has to give clearance for method. He is also falling under the same head. That is, we have got written instruction. A similar type of order may kindly be. My lord, I have got oral instruction that regarding age that will be decided in due course as observed by the Honorable Court.
There is an application and the issue problem related to date of birth. First, tell me that what should be the date of birth?
My lord, kindly. We may be permitted to give report on on this point. Only on that issue. I am praying for some time. I have got latest instruction that actually matter is pending due to right, my lord. Right, my lord. Right. We will decide this issue. Some time can be given. I am praying, man. Great.